59, my lord, I am missing out, my lord, from, my lord, important tenders. My lord, any day next week, kindly keep it, my lord, fairly at the top. Any day next week, my lord.
Mr. To come back on Monday, I'll be upgrading matters on Monday.
Wait.
I'll be upgrading matters on Monday.
Wait.
For the coming week.
Wait. I'm good.
Same prayer for 219 also I'll come back on Monday.
Please come back on Monday. Monday I'll upgrade certain matters. Yes.
Your Lordship, may I be permitted to mention item 88, Your Lordship? I would like to withdraw the matter because there are some corrections, Your Lordship.
To me, item 88 to be mentioned for withdrawal. It will appear on Monday under the heading to be mentioned.
Great.
For judgment, item 1.
I'm reading the ordering portion only. Accordingly, WPA number 14119 of 2023 is allowed on contest, thereby setting aside the impugned order dated June 12, 2023, passed by the respondent number 1 authority. Any action taken pursuant thereto thus stands revoked and reversed with immediate effect. No orders to cost urgent certified copies.
Thank you.
Thank
Do we mention item number 2 and 3 for written notes of argument?
Yes, Mr. Mishra, written notes.
My lord, I must indicate, my lord, that I have also annexed the judgments. Otherwise, the note is very small.
Thank you very much. Yes.
And my lord, insofar as the factual matrix is concerned, I have not dealt it in
no,
my
need not.
My learned friend for the City Star has dealt with the factual issues
Very
briefly. Yes.
I'm only filing my.
Yes.
I'm also filing.
Yes, Mr.
My lord, I am for the respondent number 1 of for State Bank of India. My lord, I filed written notes of arguments, short notes of arguments, my lord. My lord,
You are
both
filing.
the matters were serial number 2 and 3.
Very well. Yes.
My lord, I am for the respondent number.
Yes, I remember who you are. Learned Counsel for.
I have filed the combined in one.
Yes, that will do. Thank you. Learned Counsel for the parties file their written notes of arguments. Full stop. The arguments are closed. The matter is reserved for judgment. Thank you.
Great.
My lord, immense pleasure to address my lord.
Yes,
Thank you. Thank you. It was mutual, actually.
Same here.
I was enlightened on several aspects of the law, actually.
I'm so grateful. man.
So good. Thank you for giving us the patience here.
No, always.
Kind of heavy determination.
No, not that. Not at all. Yes, call on.
Extension of interim order, item number 4.
For the repetition.
You are for the petitioner, sir.
Lordship, I am for the respondents authority, Lordship. I am led by Mr. Shatru Banerjee. If your Lordship hear the matter today, then your Lordship kindly pass over the matter, Mr. Banerjee.
Definitely, I will not. Rest assured on that. Mr. Banerjee knows.
It's only extension of interim order, then Lordship kindly.
I'll extend for a limited period, again for a limited period, but for a larger period, and I'll put it on for hearing on it.
Lordship may kindly fix the matter by next week. We are suffering the interim order,
We
Lordship.
are also suffering in the sense that in spite of having this interim order in our favor, the railway authorities to provide a green corridor to a reader in Noida, they are not issuing the work order to us.
Very
In other
So
tenders.
that will be.
So, the interim order granted earlier is extended till August 31, 2023, or until further order, whichever is earlier. Full stop. The matter shall be listed for hearing on July 10, 2023. 10th July.
Grateful, Lordship.
Item number 5, top item.
Yes, please.
My lord, this is my application. my
Yes,
lord.
what is the matter?
My lord,
I oppose.
he has a very good case and I have a very uphill task to achieve, my lord, today. My lord, I will not trouble your lordship much, my lord. I want to take your lordship to 3 documents. My lord, one is, my lord, a mail. And thereafter, I will give the backdrop of the case. My lord, page 130. My lord, this is a mail, my lord. There was an OTS, my lord, which was there. My lord, this company had certain financial issues because of which, my lord, during this COVID period, the business went down. And my lord, they became an NPA. So based on that, my lord, 13-2 notice was issued. They had filed before the Debt Recovery Tribunal, my lord, section 19, and everything was in session. At that juncture, my lord, there was a settlement which was entered into. and there were certain terms which was laid down, and based on that, the initial down payment, my lord, of 4 crores that was paid. The total amount, my lord, when this one-time settlement was undergone, that was around 14 crores. And no, 14 initial. My lord, that after the settlement was accumulated to 12 crores, out of which, my lord, 4 crores was paid down as was promised, my lord, by selling of a property, and my lord, the balance 8 was scheduled to be paid within the 31st of March 2023. So this was the entire layout. Now, my lord, they were aware of whatever is the asset. The asset in question also, my lord, was secured, my lord, way back in 2016. Now, my lord, this is what it is. In the meantime, my lord, there was subsequent to March, my lord, it continued, my lord, there were talks, and they were also, my lord, they formulated, my lord, an addendum OTS sanction letter, which is sent to us by way of mail, that is 138. And my lord, this is the content of the letter, that is May 18th, 2023. Page 131. My lord, may I read? My lord, settlement amount of 120 million rupees out of 40 million has been paid till date, till January 31st, 2023. Balance statement amount of 80 million is to be paid, that is 8 crore, is to be paid on or before June 20th, 2023. The collateral security situated at 2nd, 3rd, 4th, 5th, and 6th floor, premises number 11 and 12, Burns Salt Gala Lane, Howrah, such and such, West Bengal, owned by the borrower, shall be released by the bank on payment of the balance OTS amount of rupees such and such. On receipt of the entire settlement amount, the personal corporate guarantee charges and such and such. Well, so this is what was sent to us. Now, my lord, kindly turns to page 133. My lord, this is the letter, my lord, wherein the entire thing was revoked. And my lord, kindly sees 31st March 2023. 31st May 2023. Now, 31st May 2023 is giving a retrospective effect, my lord, and is saying that with effect from 31st March 2023, the OTS stands revoked. And hence, my lord, this is a one-liner without any reason, without anything. And my lord, thereafter, my lord, this is something, my lord, which is alluring. And also, my lord, something which your lordship has to take judicial notice of. My lord, 19 June 2023, the next page, 134. My lord, this is how, my lord, an order is being communicated. This is the only thing which has been communicated. My lord, may I read? This is to inform you that to comply with the order, referred order, my lord, nothing, of the learned Chief Metropolitan Magistrate at Calcutta, the undersigned request you to vacate the below mentioned property by 22nd of June 2023. My lord, this is what is sent to us. After section, they have invoked 40, and this is what is they are sending to us, my lord, without anything. And this is what they have written. Not even the copy of the order has been sent, my lord. My lord, we are here ready to pay. My lord, there has been financial irregularities on our part. But my lord, the moment, my lord, they sit over from March till May, come up with a proposed letter, whatever it is, my lord, good, bad, indifferent. The terms, my lord, which is their content in that OTS, that goes because they have ratified by their own conduct that they want to extend. If not, my lord, that with 31st of March, it should come to an end.
It did come to an end.
My lord, the OTS, 31st
OTS gave you time till 31st March.
31st March.
Failed, therefore it ended automatically.
It should end on 1st of April. They should revoke it. My lord, what they have done it in April, May.
But the revocation is not necessary, is it, Ms. Chana?
My lord, only thing is, my
What
lord,
revocation is it?
my
It's
lord,
not a
their
license or a
conduct,
tendency.
my lord, their conduct kindly appreciates, my lord. What they have done is they have given us the chance, they have sent us the letter, and this is how in the one line they have done it. My lord, we have, my lord,
You are agreeable to put in that entire 8 crore plus interest since March to
my
this
lord,
date.
we need some time as a bona fide.
Sometime means what is the exact meaning of sometime?
Sometime, my lord, kindly give us some time, whichever your lordship permits, we shall arrange for it, my lord. The reason is, my lord, I tell your lordship, there was a talk of negotiation, whatever was on, my lord, based on that, my lord, we came to know that there has been certain things.
If you can, Ms. Sanal, if your client can pay 80 crore plus interest for this period,
My
for
lord,
these 2 months.
8 crores.
I'm sorry, 8 crore, 80 million. I'm sorry, 8 crore plus that interest for these 2 months, then I can request them to take instruction whether
For rescheduling.
Not rescheduling. Within 2 weeks, he'll have to pay that.
My lord, 2 weeks, my lord, perhaps we will not be able to. My lord, 2 months, we can do it.
Once I don't know whether they'll agree
My
because
lord,
of your
let me
previous
take
conduct.
instruction as the bona fide, my lord, we have brought an 11 lakhs check today, my lord. We are not wanting.
11
to
lakh.
lakh, my lord. My lord, we have to raise fund, my lord. We have to sell off the property and get the fund, my lord, honestly.
Yes.
speaking. And we have also asked for NOC. My lord, we do
See,
not
you
want
don't
to
have a
run.
fundamental or a legal right that I can enforce.
It's a mercy
only on
petition.
them.
That's why I said I have to work.
See,
uphill,
which
my
I'll
lord.
rechannelize to them because I
lord.
cannot grant their mercy.
My lord,
So,
kindly allow us.
2 months is 2 months reasonable, Mr.
No, my lord. My lord, first and foremost, I challenge the maintainability, my lord. That is my instruction. I challenge the maintainability of this writ petition. My lord, second is that this particular
Challenging maintainability on what ground?
this writ is not maintainable at all.
Against what they have come up?
If your lordship kindly takes up the prayer once. So, my lord, in the prayer, if your lordship kindly comes to prayer B at the end portion, what they are seeking for is quashing and setting aside two notice. One is that revocation notice, and the another is that the notice by which my client has asked them to vacate the property. So, my lord, two notice arises out of two actions. The vacating notice arises out of an action under SABYASACHI, for which obviously the alternative remedy is available to them. And I will show that they had full knowledge of the Section 14 order. In fact, they appeared before the magistrate's court, and the order is also recorded that
They
they have.
appeared before the magistrate.
Yesterday, my lord.
So
After we took the
So
leave,
they
we
had-
searched out there, and my lord, we found
so
out that
so
this is the
I'll place that.
date, my
No,
lord.
I'm not disputing yesterday, day before yesterday. I'm not saying. What I am trying to establish a point is that
No, the order was passed in their presence.
no. Order can't be passed in their presence. So, my lord, they had the knowledge of this Section 14 order. They have alternative remedy. They can very well go before the Debt Recovery Tribunal under Section 17(1). They can fight. Now, on that line, I have series of judgments to support my argument. The second notice, what they are seeking for is quashing, is of an cancellation of an OTS that is completely arising out of a contractual agreement between the parties. Now, my lord, there are another catena of judgment which went on to say that the writ court cannot get into the contractual dispute. And the third is that this writ is not maintainable, obviously, against the private party, because my lord would see from the cost title, RBI has only been made a party without even a single averment against them. So this writ is completely purely against the private party. My learned friend, even coming before this court to urge for any prayer, has to cross this hurdle of 3 grounds that I have taken, that writ is not maintainable on this 1, 2, 3 grounds, my lord. So without considering this thing, my lord, I cannot. And to an extent, my lord, off the record, if I may say so, the Debts Recovery Tribunal, I have already instituted a proceeding under Section 19, wherein I have got an order of injunction, over which, in fact, we went ahead and we filed the OTS letter also, and DRT is already in session of the matter. Now, in that OTS letter, after the revocation also, we have informed the DRT that the OTS has been revoked. Now, my lord, when already a court is there and is adjudicating this issue, let my friend file an interim application before Debts Recovery Tribunal in my OA proceeding and seek this prayers. That court is fully empowered to grant whatever the court thinks and consider that. But my lord, to my respectful submission, my lord, this prayers from writ court maybe is beyond jurisdiction.
So in short, they're not agreeable to that offer. That's the long and the short and the middle of the matter. So that was the only question I put to him.
That is what, my lord, I said.
So the
that he
rest
has
is
a
right.
case.
On law, he's absolutely right.
My lord, on law is absolutely right, my lord. Only benefit I can take, my lord, is paragraph 14 and 15 of Walpole, my lord, that natural justice. That upon, my lord, I have nothing to stand. My lord, only thing, my lord, only thing, kindly protects me for a limited period. We shall go and make our application.
That will open a floodgate.
My lord, in that
The
event,
precise
let
reason you
me-
have come up here. Your client has come up here.
No, my lord, this is not the
Precisely.
reason. My lord, may I just
Please,
place? My lord, may I
You
just
know
place?
the
No, my lord, we were not aware of the 14, my lord. We got this letter. My lord, we got this letter. We sought for the leave, my lord. After that,
My lord,
we
may I
carried on
again
the
say
day
one
which was there.
factual part, if my learned friend allows me. My lord, kindly comes to page 131, a factual part. Because this addendum, which my learned friend is showing at page 131, kindly see the letter. Dear Sakeji, based on your request on so and so, this subsequent discussion, please find the attached draft addendum OTS sanction letter. Please note that this is not to be considered as final approval until and unless the sanction letter is executed. So my learned friend cannot place reliance upon a draft unsigned letter.
No,
which-
May 18th, 2023,
May 18. So May 18.
the letter.
Yes.
Oh, that is a draft.
Exactly. So that is not even it is merely a draft letter and that is the reason why they have categorically mentioned in the email that please note that it is not to be considered as final approval unless and until sanction letter. My lord, it's a completely a contractual dispute. Let them sit, my lord, and they let them avail it before Debts Recovery Tribunal.
My lord, only limited, my lord, prayer I am seeking, my lord. My lord, kindly protect me for 1 week. My lord, within that, my lord, we shall prefer the application before the DRT.
My lord, may I say this?
According to you, when did you become aware of the Section 14 order?
My lord,
By this letter. By this letter.
served on 20th of
19th June is the date of the letter.
My lord, 19th June was the date, my lord, of issuance of that. 19th was the date, and 20th we came to know. We got it ready, we mentioned it, and since yesterday was the date, my lord, we went search.
My lord, may I
found out.
just hand up a copy, my lord? It is a 3rd June letter, which has been forwarded by the Chief Metropolitan Magistrate, 3rd June. We are on 23rd. That,
দেখা আমাদের কিছুটি।
no, this is the information regarding, and accordingly it was forwarded to you, client. My lord, be that as it may, my lord, I am not going into this factual dispute, my lord, time and again. In 2023 also, my lord, dealing Whirlpool and dealing all these things, the Supreme Court has again stated, my lord, and reiterated the decision since 2010 till 2020.
Learned counsel for the petitioner contends that the respondents, comma, in particular respondent number 3 and 4, comma, have acted in patent violation of the norms of natural justice by obtaining an order under Section 14 of the SABYASACHI Act 2002 behind the back of the petitioner. Full stop. It is further submitted that the petitioner first learnt about such order on or about June 20, 2023, comma, when the petitioner received a communication dated June 19, 2023, issued by the respondent bank, comma, which is annexed at page 134 of the writ petition. Full stop. Next para. Learned counsel also places reliance on Whirlpool Corporation versus Registrar of Trademarks, Mumbai, and others, reported at 1998, volume 8, SCC 1, in order to substantiate her arguments. Full stop. Next para. It is argued that even in the communication dated June 19, 2023, comma, a cryptic sentence was mentioned indicating that the petitioner was to vacate the property mentioned therein by June 22, 2023. Full stop. Although it was stated that the order of the Chief Metropolitan Magistrate at Calcutta had been referred, comma, no copy of the said order was given to the petitioner.
Not even the date, my lord.
Full stop. Next para. Learned counsel further contends that not even the date of the said order of the magistrate was informed to the petitioner. Full stop. It is submitted that there was an one-time settlement within bracket OTS between the parties, comma, pursuant to which the petitioner has already paid substantial amounts. Full stop. However, comma, the only remaining amount was rupees 8 crore and the OTS was deemed to expire on March 31, 2023. Full stop. Next para. It is further submitted on instruction that the petitioner is agreeable to pay the entire balance amount of installment of the OTS, comma, with interest if necessary for this period, for the period in the interregnum, comma, by 2 months. Full stop. Next para. Learned counsel appearing for the respondent numbers 3 and 4.
3 and 4.
3 and 4 contends that the writ petition is not maintainable ex facie. First up, it is argued that first, the petitioner's remedy lies before the Debts Recovery Tribunal, which has already been intimated about the developments in the matter by the respondent number 3 bank itself. First up, next para, that apart, it is argued that there was no concluded contract between the parties. First up, the OTS referred to by the petitioner was merely at an inchoate stage. First up, by referring to the email annexed at page 130 of the writ petition, learned counsel for the respondent numbers 3 and 4 argues that the same clearly indicates that that it was not to be considered as final approval until and unless the sanction letter was executed.
My lord, this was the addendum OTS.
First up, next para, it is further argued that the OTS proposal, which followed the said email, was merely a draft copy, sent in pursuance of the said email. First up, next para, it is further contended that this court, sitting in writ jurisdiction, ought not to interfere with the action of the respondent numbers 3 and 4, since the same was in due pursuance of legal procedure. First up, next para, a perusal at the communication dated June 19, 2023 indicates that the respondent number 3 bank had intimated the petitioner about the order passed by the magistrate, without indicating any specific date and or a copy of the order. First up, next para, however, it is well settled that the remedy of the petitioner, if any, lies in a proceeding before the Debts Recovery Tribunal, since a surface action has attained maturity. Full stop, next para, the claim of the respondent number 3 bank has already culminated in an order under section 14 of the Surface Act 2002 and, as such, cannot be reopened in the garb of a writ petition. Full stop, in next para, in any event, the petitioner is not remediless, as rightly argued by the respondent numbers 3 and 4, to the extent that the petitioners have a remedy to canvass their arguments before the Debts Recovery Tribunal. Full stop, next para, that apart, it cannot be ignored that the respondent number 3 bank is not a government institution and, as such, the scope of entertaining a writ petition is extremely limited. Full stop, next para, although the petitioner seeks a limited protection till the petitioner can approach the Debts Recovery Tribunal, such protection cannot be granted, simply because an order to that effect, without there being any special circumstances, would tantamount to opening a floodgate, thereby permitting litigants to bypass the due process of law by way of a remedy before the appropriate tribunal by filing a writ petition before this court. Full stop, hence, such prayer is refused as well. Full stop, however, nothing in this order shall preclude the petitioner from immediately approaching the appropriate tribunal for the reliefs as claimed in the present writ petition and or other ancillary reliefs. Full stop, WPA 14846 of 2023 is disposed of with the above observations.
Grateful.
Much obliged.
সার্ভিসটা দিয়ে দাও।
No.
হ্যাঁ হ্যাঁ হ্যাঁ
And such
Yes. Top item, item 2.
Yes.
But I am for the petitioner.
6.
But affidavit of service is 3 branch. From time to time, we mentioned, we informed, yesterday's leave granted, accordingly, one copy was served. Again, to
What is
Mr.
the matter, Mr.
Siddiqui is appearing for the state.
Kindly, my lord, I am praying for not today, my lord. Report has come, my lord.
No, no, it's on extreme urgency, it has been mentioned by Mr.
Yes, my
Bhattacharya
lord.
several
Actually,
times.
what has happened?
Last time in your presence,
No, yes, my lord, my lord.
That
actually, what
position
has-
be not given in the meantime.
what happened?
Oh, my lord, we misplaced this brief, my lord. Actually, my lord, I am
You
praying
are
for.
fearing that, apprehending that position may be taken in the meantime, Mr. Bhattacharya?
The position will be given on Sunday. Yesterday, the persons came from the village, my lord. They said that
What
position.
have
will
you
be given.
challenged,
My
Mr. Bhattacharya?
But challenge is, my lord, the notice, my lord, was published for inviting tender for the purpose of settlement of a fish, of some fisheries. And the same was notice was tender notice on 22nd of August 2022. Condition precedent that you must be a person participating there, must be a cooperative society, first of all. And secondly, my lord, it must be having 30 bighas of land. The particular purported cooperative society, which has been constituted after the tender notice was given, and my lord, the land was taken by them 22nd of August, the tender notice, 27th of August, tender, but they have taken a lease land on notary basis, 50 bighas of land, unregistered deed. And that accordingly, my lord, they approached the authority. 3 minor persons were made the member of the society, and we have made the objection to the district fishery officer. These are documents. Well, first of all, the land, the lease was a invalid lease under the law, under
Have you given
section
a copy to
17.
them, supplementary?
Copy has been served. Invalid lease. Secondly, my lord, minor persons have been, my lord, we have annexed the documents in support of that Aadhaar card, showing them 2 minor persons have been made the party. Thirdly, the Karmadhokko's own wife, my lord, his wife personally. He is the head of the said group, and that particular lady, my lord, is also, my lord, heading another group, which is barred under law. And conditions, my lord, will lordship appear at page 38 of your lordship's petition. Okay, for once, if your lordship pays a look on the very, very clearly, my lord, it is mentioned there. What is the conditions? At page 38, অন্তর্ভুক্ত সদস্য অবশ্যই প্রাপ্তবয়স্ক হতে হবে। First condition is, my lord, is defaulted. জলাশয়ের পরিমাণ কমপক্ষে 30 বিঘা হতে হবে। They have no land at all. Even 5 katta land is not there, my lord. They are wanting it, my lord, by way of a, my lord, purported lease, unregistered, my lord. That cannot be taken to be considered as a valid lease, my lord. And my lord, we have made a specific representation to the district for.
You want the matter to be taken up?
My lord, Monday, my lord. Because my
Grant
lord, I read the
interim
matter,
order.
my lord, kindly, my lord. We inquired the matter, my lord. This is the huge government revenue, my lord. 5th and 6th respondent, my lord. They are, my lord, highest bidder of this. This
Cannot hand over
allegation.
possession in the meantime.
My lord.
You cannot hand over possession, otherwise do the matter. Either you do the matter now or don't hand over possession till at least a week or until further order, whichever is early.
No, my lord, 1 week, my lord, kindly, my lord. Monday, my lord, 1 week, my lord. Don't give the possession, my lord, 1 week. Keep it, my lord, restrain 1
That's
week.
precisely what I'm saying.
Yes, my lord.
Learned counsel for the petitioner has made out a strong prima facie case as to the impugned tender being vitiated by the fact that the successful bidder allegedly is headed by the wife of the Karmadhoksha, who is in charge of the tender process, and that there are 3 minors who are members of
Two
the
minors.
two minors who are members of the cooperative society, contrary to the terms of the notice inviting tender. First of that apart, it is argued that the purported lease taken by the successful bidder stroke society was merely on a notarized paper, which is an invalid transfer in the absence of registration. Full stop, next para. However, comma, learned counsel for the respondent authorities seeks a day's adjournment, full stop, next para, since it is contended by learned counsel for the petitioner that even a day's adjournment may be fatal to the matter, comma, as possession may be handed over at any time to the successful bidder, comma, the respondent authorities are restrained by an order of injunction from handing over possession of the property in question in favor of the successful bidder pursuant to the impugned tender till we are on till June 30, 2023, or until further order, whichever is earlier, full stop. The matters shall be listed fairly at the top of the list on June 26, 2023.
Affidavit of service and supplementary affidavit will not be kept.
Affidavits of service filed today be kept on, and no, sorry, affidavits of service and supplemented affidavit filed today be kept on record.
Grateful.
Fairly at the top of the order.
New motion, item 7.
Lordship, I am on behalf of the petitioner, Lordship.
Yes,
Lordship, before making my submission being a junior advocate, I want to say one thing.
Yes.
Lordship, after receiving this brief, repeatedly I asked myself whether this writ petition is maintainable or not. And Lordship, earlier night I have done one research work and I got an order of this Honorable High Court regarding similar matter. So after perusing this order, then I am sure that this writ petition is maintainable. Now I am asking myself, what is the brief fact of this, of the grievance of the petitioner? Lordship, against your petitioner, one FIR has been initiated and petitioner also lodged an FIR. So 2 case records are in the learned court below. And Lordship, astonishingly, from the year of 2020, these 2 case records are completely missing. And due to that reason, being a prudent person, Lordship, first your petitioner preferred an application before the concerned court to find out this record. And the concerned court, that is the learned Additional Chief Judicial Magistrate Barakpur, passed an order in favor of the petitioner to find out the case record. But ultimately, the case records were not found out. Then your petitioner sent a representation to the concerned authority. And after receiving the representation, the authority concerned is completely silent. Okay, is completely
Which authority?
Lordship, learned district judge, learned additional district judge, judicial department, secretary judicial department, additional chief judicial magistrate, and the court officer. All authorities are maintaining silent nature. And Lordship, repeatedly I asked myself that this kind of action is coming within the ambit of administrative action.
Why is that it not maintainable? Because it's judiciary.
No, no. Actually, I am asking myself that whether this writ petition is maintainable or not, because the respondents are the district judge, additional district judge, but all
this is administrative action.
Yes. I am pointing out this point that this is administrative action, and when this is administrative action, so this writ petition is maintainable. Lordship, in that event, Lordship,
your night's research have gone in waste.
Lordship,
thank you for that. Yes.
And Lordship, in that event, Lordship, I humbly draw your Lordship's kind intentness on page number 45. Regarding a similar matter, His Lordship, Honorable Justice Mr. Devanshu Bosak, was pleased to pass an order to find out the case record. And ultimately, after filing the writ petition, the case record was found out. But Lordship, in that event, Lordship, these 2 case records are completely missing. Now, the problem is that, Lordship, suddenly the case record has come out, then the warrant will be issued against the petitioner.
So your FIR and counter FIR were by you and the private respondents?
Lordship.
Achha, which court the records are supposed to be lying in which court?
Lordship, in the court of learned Additional Chief Judicial Magistrate Barakpur.
Yes, what do you say? I'll pass a direction.
Lordship.
I'll seek for a report, actually keep them at a pending.
Lordship,
Otherwise it will never be found.
Lordship.
Learned counsel for the petitioner rightly contends that the writ petition is maintainable, since an administrative inaction on the part of the respondent authorities, who are a part of the judicial hierarchy as well, comma, is in question. Full stop. The grievance of the petitioner is that the petitioner and the private respondents filed complaint and counter complaints against each other, comma, which resulted in FIRs being registered. Full stop. Subsequently, cases were initiated.
Yes,
Obviously,
because the FIRs are there,
subsequently
Lordship.
criminal cases were initiated bearing number. Have you given in the
Yes, Lordship, I have given the FIR against the petitioner. The number of this FIR is Belghoria PS case number 190 of 2017. And another number that
please
is
write
the-
in a sheet of paper and give it to my office.
Lordship. Lordship.
Which paragraph? Tell me that. That will also
Lordship,
suffice.
Lordship. I'm coming to this paragraph, Lordship.
আচ্ছা, being number না দিয়ে full stop করে দিও ওখানে।
And Lordship, paragraph number 3 and
the relevant numbers of
paragraph
the
number 5.
the relevant numbers of the cases are Belghoria Police Station case number 190 dated February 27, 2017 and Belghoria Police Station case number 404 dated May 4, 2017.
Lordship.
Full stop. Next para. It is contended that despite repeated representations, comma, lastly to the district judge, comma, Barasat, comma, district North 24 Parganas, comma, nothing has happened regarding tracing out of the relevant documents in connection with the said cases, comma, due to which the petitioner is in constant agony and apprehension of the fallout of sudden discovery of such records. Full stop. Next para. Heard learned counsel for the parties. Full stop. The petitioner is undoubtedly justified in agitating his grievance that the petitioner is in constant stress due to the records of the criminal cases in connection with his complaint and counter complaint of the private respondents having gone missing. Full stop. Hence, comma, the respondent number 2 and the respondent number 4 are directed to file reports as regards the current whereabouts of the records of the said 2 above mentioned cases through the registry of this court. Full stop. The registry shall place such reports to be tagged with this file before the next returnable date. Full stop. Such report shall be submitted by the respondent numbers 2 and 4 as expeditiously as possible, comma, positively within July 31, 2023. Full stop. Immediately thereafter, comma, the registry shall place the reports as directed above with the records of the case. Full stop. The matter shall next be listed on August 14, 2023, fairly at the top of the list for here.
I'm deeply obliged, Lordship. Actually, research work is very, very enviable for our profession.
Definitely. Always. Always.
I'm deeply obliged, Lordship.
Item 8.
Yes, please.
My lord, I am for the bank.
Right, right.
I am for the state.
Yes, yes.
Follow the case of the petitioner, my lord,
Yes.
that the order passed by the
Can you
district
please come
judge-
a bit closer to the microphone? Yes. Case of the petition.
order passed by the
It has to go down. Mic. Yes. Thank you. Yes.
my lord, I'm challenging the order passed by the district magistrate Howrah. Because when the bank has filed an application, any notice of that application has not been served to the petitioner.
Section 14.
Section 14. No, my lord, you are not even or any order has been passed. Order has been passed. That was also not communicated.
Where does your remedy lie?
That your lordship, what your lordship think. My lord, I am the grantor. I am not the borrower.
All of you have the right to
Liability.
approach this tribunal.
Yes, my lord.
Go
But
ahead.
my lord,
My lord,
only
the
I-
property has been sold and sale certificate was issued on 16th February 2023. My lord, may I hand over a copy of the my lord, sale certificate, my lord, issued by.
Yes. Please give a copy to him also.
Yes.
My lord, because my client,
Yes.
same, he my lord submitted one-time settlement, 43 lakhs. Claim is 41 lakhs. And he wanted to pay at a time.
He is not the owner. He is not the owner of the property. The owners
Yes.
of the property has not.
No, I am
before
the
your lordship.
grantor. I am the owner.
The grantor.
There are two premises. I am the one of the owner of the another premises. What they did, my lord, with the help of their my lord marshalman and the recovery agent, my lord, they came to the in front of the petitioner, removed the petitioner just my lord aged about 70-75, remove them forcibly from the house. My goods belongings lying in the house, my lord, and I am on the street. But that particular
kindly
grantor,
turns to
he
page
wants to pay
45.
the entire amount. Because I have made a representation that I one-time settlement, 43 lakhs, that was not
So
considered.
what have you challenged here?
I am
Revision.
challenging, my lord, the order passed by the district magistrate is illegal. That is violation of the principle of natural justice. Any order has not been communicated. I do not know what order has been passed. Suddenly they came and, my lord, threatened me and ousted the petitioner. And all
What
goods
is the
belong.
use if the writ petition is kept pending? You have already been dispossessed. Even if this is kept pending, I cannot direct your repossession at this stage. If I can't direct that, your exercise will be futile. Better to approach before the surface, the tribunal. I'll give you that liberty.
I filed two applications in connection with this here. One application for addition of parties. I don't know, my land friend will inform me who is the purchaser. My lord, they did not inform me. That
My
is
lord,
one aspect.
That is mentioned in the, my lord, the sale certificate. I have handed.
Another, my lord, another my submission that I have filed an application for addition of parties to the alleged purchaser, number one. Number two, my lord, I filed
Writ petition, if the writ petition is not maintainable, the addition of party
Yes,
goes.
that-
I'll give you liberty to approach the tribunal
My lord,
after
here,
hearing. Yes.
kindly color see, my lord, the prayer A, my lord, section, page 15, my lord, he himself said that section SF 58, 2022.
Yes, I can grant A also. He's right.
My
Your
lord,
learned friend is right. I can grant your prayer A. But I cannot grant now because you admittedly are out of person.
Yes, my lord, the
what, my lord, I'm saying?
Your prayer is cannot take illegal forcible possession without due process of law under section 17 of the Surface Act.
Well.
Now they have already applied that provision and they have got possession. So both these prayers are now infractuous. Even if I grant this, cannot help you. You'll have to go before the tribunal. Go there. I'll give you that liberty.
My lord,
lord,
you
page
will sorry,
40
grant me leave, but meanwhile, my lord, we should not be, they will not take possession of that because
They have taken possession, admit.
no, my lord, my goods belonging, everything is there.
Goods are outside, you are sitting inside.
My lord,
Your
no.
goods are outside on the street
No.
and you are inside.
I am not inside. They have removed us, but goods are valuable. Goods are everything is lying. They put a padlock.
That is their possession. They have taken possession, therefore. Goods are lying there, definitely have an action before the tribunal.
and my lord, they have also.
I'll relegate them to the tribunal.
Yes, my lord, and they have also received summons, my lord. My lord, bank has filed section 19 application before the debts recovery tribunal, my lord, page 45. They have themselves admitted that they have received the summons. Page 45.
Yeah, we have taken step. We have filed written statement in that section 19 application.
They can make an application therein also. Page 45, my lord, P5, annexure P5, this is the summons, my lord.
I have not suppressed. Well, I have stated the petitioner appeared, filed written statement and contesting that proceedings.
The present petition has been challenged against an alleged illegal action on the part of the district magistrate in passing an order under section 14 of the Surface Act 2002 in favor of the respondent bank. Full stop, next para. Learned counsel for the bank, comma, at the outset, comma, challenges, disputes the maintainability of the writ petition and submits that the sale certificate was already issued on February 16, 2023. Full stop, next para. Not only that, comma, possession has already been taken. Full stop, that apart, comma, even as per annexure P5 at page 45 of the writ petition, comma, summons were served on the petitioner with regard to the proceeding under section 19 within bracket 4 of the debts recovery of the recovery of debts due to Banks and Financial Institutions Act. as well as under Rule 5 within bracket 2 capital A of the DRT within bracket procedure bracket close rules, 1993. Full stop. As such, the present writ petition ought to be dismissed. Full stop. Next para. Upon considering the submissions of parties, it is clear that the petitioner has himself, the petitioners have themselves submitted that they have been ousted from the property in question, although valuable goods, according to the petitioners, are lying in the suit in the disputed property. Be that as it may, apparently possession has already been taken by the respondent bank in pursuance of the law, and a sale certificate with regard to the property has been issued as long back as on February 16, 2023, a copy whereof is handed over in court as well as to the learned advocate appearing for the petitioner today. Next para. Moreover, it prima facie appears that summons were served on the petitioner with regard to the proceeding under section 19 within bracket 4 of the Act. As such, there is no scope of interference under Article 226 at the present juncture. However, nothing in this order shall preclude the petitioners from approaching the appropriate tribunal and or before any other forum, if available in law, with the grievances as raised in the present writ petition. WPA number 13662 of 2023, along with the connected applications, are accordingly disposed of in the light of the above observations. No other.
Only, my lord, your lordship, my lord, rejected, your lordship kindly dispose of this order. Dismiss, your lordship.
Ask your learned junior what I did. You are ready for the rejection. That's why I should have rejected actually. I said dispose of. Ask your learned junior.
Item 9.
9 is.
9, your lordship. Miss Nonita Sharma is appearing on behalf of the petitioner. She is unable to connect to the link, your lordship.
Connect to the link?
Link, yes, your lordship. I'm praying for some time because the service is also not completed yet.
The service is not yet complete. Moreover, it is submitted that learned counsel for the petitioner is not being able to connect to the video conferencing mode for arguing the matter. Accordingly, let the matter stand adjourned for the day.
My lord, I am for the petitioner.
In which
Item
matter?
10.
Item number 10.
Yes.
But I am appearing for the state.
My
State.
lord,
For the state?
Yes.
Allowed.
my lord, kindly grant me liberty to file surface application before DRT 3.
Thank you for your intelligence and sharpness. On the pair of learned counsel for the petitioner, WPA 14162 of 2023 is disposed of with liberty to the petitioner to move the appropriate tribunal with the self-same reliefs as sought in the present writ petition, no arrest to cost. Thank you.
Item 11.
Appear for the petitioner.
Here for the state, right? Yes. Yes, Mr. Bhattacharya, what is the matter?
The petitioner.
You are for?
Your lordship, I am representing in person. I have represented myself in 2018 before you also.
Yes.
I've got the order where you have mentioned I have submitted.
You are which of the respondents?
I am respondent number 12, your lordship.
12. Thank you.
I'm going to expose the entire issue with backed by truth, and I'll speak last. Right.
Please take your seat for the time being.
Yes. I have no grievance against him also, my lord.
Mr. Jaiswal, please take your seat for the timing. I'll just call upon you.
Petitioner.
Let me hear the petitioner first. Take your seat.
I'm the respondent 12.
Have a seat. Sit down.
Petitioner, the respondent number 12, obtained a loan from the State Bank authorities, and that was, he did not comply. It was declared NPA, and subsequently, I entered into that proceeding, and sales certificate was issued in my favor. Page 16, my lord, annexure P2. After the sales certificate was issued, the bank approached the district magistrate. Kindly comes to page 17, annexure P3.
No, sales certificate was issued
in 2013.
In whose favor?
In my favor.
Achha. So who was the borrower, you said? 12.
12.
Acha.
Now thereafter, my lord, 17, these processes, page 17, my lord, the bank approached the district magistrate under, an order was issued under section 14. Thereafter, my lord, the state bank stepped complete over this issue. I made representation. It was between the respondent number 12 and the state bank, who has taken loan and who has not complied. Sales certificate was issued. Thereafter, I given 33 lakhs, sales certificate was issued. But till date, no possession was ever issued in my favor. I approached it, made representations to the state bank.
No possession has been given.
No possession has been, only sales certificate. Till date, nothing. In spite of this order of the district magistrate, state bank has not yet issued any possession.
Is the order of the district magistrate?
Page 17, my lord.
17A.
Type copy, page 17A, my lord.
Relevant 18.
Kindly comes to page 18, my lord.
11% top. 18.
Accordingly, as per amended of section 1A of the Services Act, Sri so and so is hereby authorized to take possession of the assets document relating hereto and forward the assets document to the secured creditor with police assistance.
Section 1A.
This was issued. Kindly sees my lord, filed under petition under section 14 of the Services Act 2012.
Very good.
This was done.
So you are wanting that possession now?
Either you refund the money with interest or take possession or give.
Have you asked for that?
But kindly, my lord, see, my lord, I have.
Refund or possession you have asked?
My kindly sees, my lord, the similar question came up before this. Kindly comes to page 49 once, my lord. I have also made this order available to the state bank authorities where a similar thing happened, my lord. But kindly sees, my lord, in the writ petition. The petitioner requested the state bank to make over the possession of such property. State bank failed to do so. Various correspondents approached the state bank through advocate's letter. The petitioner before me submitted the state bank is not in position to make over the immovable property, and the amount paid by petitioner should be refunded with interest. But they are utilizing the my.
I am asking you, have you sought for the refund?
I have asked my lord. My kindly sees my lord.
11B.
এক minute. এক second. My kindly see page 21, my lord. I made representation to the state bank. But they are utilizing the money. They may give the interest upon that money to me. In the writ petition, I also paid that. Did they give interest on this amount?
You have asked for possession and interest.
My lord.
You have never asked for refund.
The state bank is utilizing the my money.
Have you asked for refund at all?
No, I have not. No, I have not. I have asked for the interest.
Anyway, let us hear the state bank.
My lord.
First, I'll hear the state bank, then I'll come to you, Mr. Jaiswal. I'll come to you last. Let us hear the bank first. Yes. Who is appearing for the bank? Bank
served. They have received.
Then you, Mr. Jaiswal. Yes. Mr. Bhattacharya, please take your seat. Yes.
Your Lordship, my submission will be a little long because I have to express the entire truth with all supporting documents before you. If you see in page number 6, the petitioner tells lies before you. It is needless to mention that neither the sale order nor the order of the district
Page 6
magistrate
of what? Page 6 of?
Of his petition.
Which paragraph?
Your Lordship, paragraph 9.
Acha. Yes.
It is needless to mention
I'm not finding that out.
Neither the sale order nor the order of the
No,
district
that is,
magistrate.
you are reading the same writ petition. Mr. Jaiswal, it's not there in my copy.
Sorry?
It is not there in my copy what you are reading.
Just Page 6, paragraph 9.
Paragraph 9.
Middle portion. Acha, thank you.
Seventh line.
Yes, needless to mention that, please continue.
Page 6, para 9.
Now I've got it. Yes, it is needless to mention.
It is needless to mention that neither the sale order nor the order of the district magistrate has been challenged in any court, nor any order is obtained till date, thereby staying its implementation. Now I'm going to nail the truth. Your Lordship, he has shown an order of the district magistrate of 2017. I am showing you an order of the district magistrate of 2018, which has stayed the order. That means they are misleading and misguiding, and this is also a case of perjury, which I'm going to bring entire.
Mr. Jaswal, if you want to bring those facts on record,
Yes, yes, Your
I'll permit you, but then you have to file a short
Yes,
affidavit.
yes, Your Lordship.
I'm not passing any interim order. I'll direct you to file affidavit, annex all the documents there, and say whatever you have to say.
Your Lordship,
I want to keep it on record.
Yes, yes, Your Lordship.
Yes.
Yes, that I will do, Your Lordship. Here, the district magistrate has stayed the order because the bank on affidavit has suppressed that there is a DRT stay. There is a CGM order.
Just to save your breath for the time when the matter is heard finally, because I am already permitting you to file affidavits. You will bring the entire facts on record.
Yeah.
No need repeating. No, keep this with you. Annex this to the affidavit which you are filing.
And Your Lordship, last thing, even when the Chief Justice of this court said, "Don't sell," they sold. DRT said, "Don't sell," they sold. Everything I'll bring on record before you.
I'll indicate that. Yes, I'll direct affidavits in this. How soon can you file your affidavit annexing all these documents? Tell me
Kindly consider, I have given 33 lakhs, which is being enjoyed by the State Bank authorities. I have no grievance against them.
How soon can you file your opposition?
If Sir, Your Lordship, he is quoting Justice Basak that no possession.
How soon can you file your opposition,
my
Mr. Jaiswal?
Okay, sir.
Learned counsel for the petitioner submits that despite the petitioner enjoying a sale certificate in his favor from an auction sale in connection with a debt taken by the respondent number 12, the petitioner is not getting possession of the property, nor any refund of the amount paid by the petitioner. Next para, such contentions are controverted by the respondent number 12, who, with leave of court, is appearing in person. It is submitted by the respondent number 12 that the petitioner has made incorrect statements in the writ petition, in particular paragraph number 9 thereof, where it has been averred that it is needless to mention that neither the sale order nor the order of the district magistrate has been challenged in any court. It is submitted that, contrary to such statement, a stay order was passed by a competent forum against the said order. Next para, that apart, it is alleged that the petitioner is even otherwise guilty of perjury and have suppressed several materials before this court. Since the respondent number 12 seeks to place before the court certain documents and to bring on record certain facts which according to the respondent number 12 are relevant, the respondents ought to be given an opportunity to file affidavits. Accordingly, the respondents shall file their affidavits in opposition within 3 weeks from date. 2 weeks. Within 2 weeks from date. Reply, if any, shall be filed within a week thereafter. The matter shall be listed on July 17, 2023 for hearing. It will come up on July 17th for final hearing.
Your Lordship,
Affidavit of service filed today be kept on record. Yes.
Kindly record that State Bank has not participated so that I can give a notice to them authorities also, because their presence is essential, my lord.
No, give a notice.
If
I pass my order.
If my lord so direct that on the
Then non-appearance will be evident from the record itself. Record shows only you are appearing, you are for the state. State is appearing and he is appearing in person. Respondent number 12 in person or onader namta ja ache record.
even your Chief Justice order has been.
No, yes.
Show you, Your
I'm keeping it open for you to argue so that I don't want to restrict you to only these arguments.
Thank you, Lordship.
Thank you. Next.
Item 12.
12, yes.
My application.
Yes, sir.
Lordship, I appear for the respondent bank. Lord, I do not know what are the prayers in the writ petition because the writ petition was served without any number.
Number. Copy though. Is the prayer in the petition?
The prayers are not there.
No, the number of the writ petition is not, which has been served on the bank.
No, you are saying you don't know the prayers. Prayers are also
But
not
what
there.
is there before Lordship, I do not. Number
WP number नहीं था बाकी तो अच्छे खाने prayer.
কোন writ petition file করেছেন?
No, WP number is not mentioned in supply copy. WP number, it is there in the list also.
It was not filed at that time, it was served.
Very small, grievance.
I am taking the point of maintainability of this.
Yes, sir.
Because of non-giving of the number.
No.
Let me place, my lord. Small matter.
I'll
Petitioner,
pick up your maintainability point also when I hear.
Lordship.
Yes.
petitioner are the borrowers. I took loan of 50 lakhs against my flat.
How many lakhs?
50 lakhs.
50 lakhs.
50.
Yes.
There was a default due to COVID. I could not pay. Not proceeding has been initiated by the bank.
Right.
13.2 is there. 13.4. Then, my lord, they issued a notice that you will be declared willful defaulter on 15 November 22. On next day, they issued a petition notice. My lord, thereafter, my lord, I filed section 17 DRT. I am filing an interim petition that is being contested by the bank. Now, they are now going to declare me willful defaulter without giving a hearing to me. My grievance is you can, under there is a mechanism of the RBI, my lord, the master circular, that when you can declare willful
Because has been issued to you.
so I was called for personal hearing. I could not appear. I issued a letter, please give me a personal hearing, fix a date. Any day I will come and join. But there is no reply. Although they have received the letter, but there is no response. I am apprehending, my lord, they can declare me.
Declaration has been made in the meantime.
My lord.
You have been declared to be a willful defaulter.
No, they have given notice to declare.
You have not yet
Let
declared.
him give
Why
the
not you
hearing.
declare? I'll haul you up for contempt.
No, but it is a show cause notice.
Should have declared by now.
But it should have.
Why not? So then if you have not done that, give him another date of hearing.
Lord, we have asked
I'll
him.
dispose of the writ petition.
Lord,
give him a
we
date
have
of hearing.
asked him to calm down to, they wanted to calm down to.
CALM or COME?
I leave it to Lordship.
No, calm down or come down.
No, it is the head office is there in Karnataka. Now they do not want to go there. Lord, they have requested for a personal hearing in Calcutta. Lord, we are still at the hearing stage, Lord, so that they can be given a hearing. In even in VC, we are thinking of that. That meeting has not been concluded as yet. So, Lord, I was praying that
I have not given a-
infractions because it is a premature one.
But I am not given
a show cause notice, the repetition will not lie. And that to Lord, it is a private bank. And Lord,
Yes, right.
Lord, there are judgments, Lord. I want to place those, but since your Lordship,
Those
And if
before the
page-
next forum.
Page 213, my lord, I have given my letter requesting them to give a personal hearing and fix the date of hearing. He
The
received
counsel for
no
the
reply.
petitioner submits that the petitioner was unable to repay a loan, for which a proceeding under the SARFAESI Act was initiated, which is being attended by the petitioner. Full stop. That apart, the bank, respondent bank is seeking to take possession from the petitioner as well as to declare the petitioners to be willful defaulters. Full stop. It is contended that the petitioners have sought for a personal hearing, without giving which the respondent bank is intending to declare the petitioners as willful defaulters under the corresponding master circular of the RBI, Reserve Bank of India. Full stop. Next para. Learned counsel for the bank contends that the writ petition is not maintainable and is premature. Full stop. Apart from the fact that the respondent bank is not a government or nationalized bank, the other fact remains that the petitioner does not have any cause of action as yet, since no declaration of willful defaulter has been taken by the bank. Full stop. Next para. The petitioner, the petitioners, it is contended, seek to avoid appearance in Karnataka, which is the head office of the respondent bank, for which the respondent bank is even considering the possibility of giving a hearing by way of video conferencing. Full stop. Be that as it may, the the bank is justified in pointing out that the writ petition at this juncture is premature. Full stop. Only a show cause notice has been given to the petitioners by the bank for giving a hearing on the declaration of willful defaulter. Full stop. Such proposed declaration has not yet furnished any cause of action to the petitioners. Full stop. However, since the bank has taken a rational view in considering video conferencing as an alternative mode of hearing, the bank shall reach a conclusion on that in that regard as to whether the petitioner should be given a personal hearing or a video conference hearing for the purpose of the proposed declaration of willful defaulter. Full stop. Next para. Such hearing shall positively be given to the petitioners by prior notice by the respondent bank in writing. Full stop. There is no further scope of any interference as such, full stop. Accordingly, WPA 14219 of 2023 is disposed of without any orders to cost in the light of the above observations, whatever that means.
No, only one indulgence, my lord. Petitioner personally or through lawyer?
No, the lawyer is not, your lordship has held in many judgments, my lord.
I'll not open that. Keep that reserved for the next round of it.
No, now it is well settled of the EMC case passed by your lordship.
Not only that, and otherwise also, I mean, why not video conferencing?
No, then lord,
Video conferencing, you will be able to take the issue of technical snag. That will be an additional issue in your next writ petition.
No, my lord is.
No, could it be not and also authorized representative?
Whatever. I'm keeping that open.
Anything is there in the statute, my lord, there.
Better ask them what sort of an environment they want for the hearing.
Not we are.
And what sort of amenities.
Not
Give
kindly.
them that and then do the
Kindly
hearing.
do not record it, my lord. We are trying to have the hearing in Calcutta. We are trying that.
Yes, I will be grateful to them.
But that will be a bad precedent for them.
Absolutely.
Not they are going to recover their money. They are going to sell my flat. Even if they are to, if I am declared willful default, it will finish my financial life.
You know, pay the dues of the bank.
Yeah, sale notice there. Sale notice. If it is sold, money is recovered, then what remains? Why I should be declared willful defaulter?
You're portraying them as criminals, but Mr. Theory, your client should have been aware of this before
Yes,
taking the
he
loan.
should have been.
My
I am
lord,
grateful to you, Lord.
I have not used any affidavit, kindly, my lord.
My lord.
Since no affidavits have been directed, it is deemed that none of the allegations made in the writ petition are admitted by the respondent.
I'm grateful.
Item 13.
My lord, I am for the petitioner.
Yes.
My lord, this matter was scheduled to appear in your lordship's list on 26th, my lord. Today.
No, in the computer sheet, it has been written 23rd. Accordingly, it is appearing.
Actually, my lord, in the slip which was issued to me, it was written 26th, my lord.
Have you got that slip?
Yes,
Have you
my
checked
lord,
up
I have
personally? Don't show me. You check up personally.
Yes, ma'am. Yes,
You
my
have checked up.
Yes, my lord.
Learned counsel for the petitioner submits that the petitioner was under the mistaken notion that the matter will be listed on June 26, 2023, full stop. Accordingly, let the matter stand adjourned till the said date.
Deeply obliged.
Thank you.
Item 14.
Lordship, service of affidavit is still waiting for confirmation.
Affidavit of service. Can you do it during the course of the day? Then I can hear you also.
And my senior counsel also busy now.
Very well. On the prayer of learned counsel for the Tuesday, on the prayer of learned counsel for the petitioner, the matter is adjourned and shall next be listed on June 27th, 2023.
Grateful, Lordship.
Item 15.
My lord, is
Yes.
my application.
Service?
Yes, my lord, I have served the competent authority constituted under the, my lord, West Bengal Apartment Ownership Act. He has refused to, my lord, accept the service.
It uses good services.
Yes.
But have you annexed that to the
Yes, yes.
What
Yes,
is
my
the
lord, the
matter?
petitioner, my lord, he is a manager.
Others have been served.
Yes, others have been served. Some have refused. Some of the private respondents, they have refused. The endorsement is there on the envelope. Read it.
Yes, what is the matter?
Yes, my lord, the petitioner before your lordship, he is a manager, my lord, of the board of managers of an association formed under the West Bengal Apartment Ownership Act. My lord, I have lodged complaint with the competent authority. My allegations are against the board of managers. My lord, there are 4 allegations I am seeking to level against them. Number 1, the funds of the association is being misused. Number 2, they are, my lord, acting in detriment to the, my lord, interest of the association. Third is, my lord,
The consideration do.
yes, my lord, bylaws are being violated. AGM of 2021-22, my lord,
If I direct the
Yes.
authorities to consider, that will do.
that will do, my
Shall
lord.
not direct affidavits in this matter unnecessary.
Yes,
Where is your representation?
yes, my lord, the last representation, lordship will find at page 38.
No, the previous allegations are also serious.
Yes.
Those have not been repeated in at page 38. Page 33 is also serious, probably.
Yes, page 33 and 38, my lord.
I'll direct them to consider both.
Yes.
Despite service, none appears. Despite service, none appears for the respondents. Full stop. Affidavit of service filed today be kept on record. Full stop. Since some of the respondents have refused to accept, comma, it is deemed that good service has been effected under the law on all the respondents. Stop. Next para. The petitioner alleges that despite the petitioner having brought to the notice of the respondent authorities serious allegations regarding the dealings of the association of apartment owners with regard to Merlin Uttara Apartment Owners Association, comma, no steps have been taken in that regard by the respondent authorities. Any particular respondent whom you want to consider?
No, my lord, it is the board of manager who is responsible for the affairs of the
No,
association.
who will consider the representation?
The respondent number 2, my lord, the competent authority.
Full stop. Since it would be premature to enter into a discussion on the merits of the said allegations at this stage, comma, WPA 14387 of 2023 is disposed of by directing respondent number 2 to immediately consider the representations made by the petitioner as annexed at pages 33 and 38 of the present writ petition, and comma, upon giving an opportunity of hearing to the petitioner as well as to the persons against whom accusations have been leveled in the said representations, comma, to come to a definite conclusion in accordance with law and procedure as expeditiously as possible. Full stop. It is expected now. The exercise shall be completed by the respondent number 2 in its entirety within 2 months from the date of communication of this order to the respondent number 2, full stop. The said respondent shall act on the said respondent. The respondents and all concerned shall act on the communication of the learned advocate for the petitioner, comma, accompanied by a server copy of this order for the purpose of due compliance of the same. No rest to cause
My
urgency.
lord, only one indulgence. In the meantime, lordship may kindly direct the competent authority to ensure that the, my lord, interest of the apartment owners are, my lord, protected.
একটা লাইন অ্যাড করে দাও ওই যেখানে নো রেজ টু কস্টের আগে it is also expected that who will look into that? Competent authority.
Under section
It is
16B,
also expected that the competent authority, that is respondent number 2, shall ensure that the interests of the flat owners of the said apartment are protected in all manner in the meantime.
I'm grateful.
এটা দিয়ে তারপরে
Item 16.
Appearing for the CSC, Lordship.
Appear on the petitioner.
petition.
For the state respondent.
New connection, petitioner duly applied, and the CSC authority might came for inspection.
Private respondent.
It was obstructed, then page 13, kindly see.
My lord, we are unable to hold the inspection.
because steep resistance was offered by the respondent number 4.
They have no
And
nexus with the
they,
property.
they have given a
I'll
letter.
come to you. Without that, I cannot decide the matter. Yes, let them complete. Yes. Yes, complete your submission. You are saying something.
Yes.
Could not hold inspection and
This is the passage related issue, Lordship. Unless that
Mr.
cable is,
Chatterjee, this is the state's report.
no, this is the state report. ma'am. Unless the cable is laid down, Lordship, the new connection cannot
What
be
is
given.
this?
This is an objection by respondent number 4.
It's a civil dispute is pending, it's a fact. In the civil court, matter. At the same time, there are some interference.
Yes, tell me.
Only one thing, my lord, I am
Please take the microphone.
presently I am not holding the brief via phone.
That is not a
telephone.
ground for refusal of election.
No, my lord, I have not received the Wakalab number from the respondent. Just received a phone call to appear. Only not today.
No, no.
Only, my lord, not today.
I'll only direct you to give electricity connection.
That's
Why not today? What is your instruction over the phone? What is
just
your
to
objection?
appear. What? Today, in the due course, I will receive the Wakalab number as well as the petition. I am not holding that petition as well as the Wakalab number.
Lordship, we coming to the last line.
Only
Last line.
not today, my lord.
Last line of the objection.
I'll give him because he does not hold his vokalatam, he will not get the appearance also.
Yes, what happened? Yesterday evening, the police authority went to my client's house and told that you have filed any case before High Court. Yes, there was a paper. Replying with my advocate. Again, midnight, 2 o'clock, police again went to my client.
For that, you have to catch hold of Mr. Chatterjee.
Yes,
Yes,
but I
my lord,
told
he
him-
told me, my lord.
I can also catch hold of him if you see.
I told him already.
My lord, I have to ask my lord, why they went there, my lord.
Yes, yes. Mr. Chatterjee, please ensure that
The agent lady, my lord.
Learned counsel.
Police authority, my lord, when what happened, my lord?
Learned counsel for the petitioner complains that the private respondents, who have no connection with the property in question, are interfering with the petitioner's right to get electricity connection at his premises, for which the petitioner has already applied in due course of law. Full stop, next para. Learned counsel appearing for the CSC Limited supports such contention and submits that due to active obstruction by the private respondents and their men and agents, no such connection could be given to the petitioner and/or
inspection.
Any inspection also could not be held. Full stop. Next para. Learned counsel for the private learned counsel having instruction to appear for the private respondents seeks a day's adjournment to have appropriate instructions in the matter. Full stop. Learned counsel for the state files a report which is kept on record, along with the copy of a written objection handed over by learned counsel for the CSC Limited, which has purportedly been given by one of the private respondents, namely Raju Pal, within bracket respondent number 4. Full stop. Next para. In view of the prayer for adjournment of the private respondents, let the matter stand adjourned for the day and shall next be listed fairly at the top of the list on June 26, 2023. Please come prepared on Monday, take instructions, and Monday I'll definitely hear it out. Fairly at the top of the list.
My lord, grateful lordship. My lord, I am assisted by Mr. Amitolal Chatterjee. my
Give the
lord.
names on a slip of paper, give so
Sure,
that
sure,
they'll otherwise misplace.
হ্যাঁ গো দাদা, আমি অবশ্যই কথা বলছি।
Item 17.
My lord, I appear on behalf of the petitioner.
What
My
about
lord,
service?
Affidavit of service completed.
Good service on all?
Good service.
Yes, what is that?
My lord, it's a very simple case of inaction by the respondent authority. The respondent authority here being the superintendent of the SSKM hospital. I'll just go into the facts a little bit, my lord. In 2013, my mother passed away. I'm the petitioner. My mother passed away due to medical negligence by Medica Hospital. In 2015, I filed a complaint before the State Commission, Consumer Commission. Proceedings are going on. We exchange objections, questionnaires, everything. In 2022, I filed an application for an expert committee to be set up. expert committee to set. I filed a application before the state commission that an expert committee be directed from some government hospital so that the question of negligence can be gone into, whether or not there was negligence. Similarly, one of the doctors responsible for the negligence filed a similar application. Both were taken up together. Order was passed on 12th May 2022 that the IPGMER SSKM hospital be directed to set up a expert committee to look into the negligence and submit a report within 3 months. That date was 14 September, the returnable date. On 14 September, there is an order that is annexed to 2, I think, that no report from the SSKM hospital. Similarly, on 4 other occasions, subsequently 19th November, December, January, and 3rd March, finally.
Last year.
Like December 22, and then 1st January and like 3rd January and 3rd March, I think, orders that no report from SSKM is there and petition and every parties are appearing. 3rd March, the order is that the final date of hearing is again 31st August. After this order, the petitioner approaches me. I write a demand justice letter to the SSKM hospital, the superintendent. You set up the committee and give a report. No reply. My lord, after that,
The committee has to give a hearing to you according to the order of the state commission.
my lord, no, my lord, the committee has to, first the SSKM hospital has to set
That
up
will
the
be an
committee.
internal sort of inquiry.
Yeah,
Not internal.
not internal, because it is an expert committee by an
IPGM.
external agency. My lord, I'll just request my lord to go.
That order.
Yes, the order is
Well-
at page 16, annexure P1. Page 17 is the relevant operative part, my lord. Paragraph 7. Shall I place it, my lord?
No, what sort of a direction are you expecting here?
My lord, a direction to the SSKM hospital, the superintendent SSKM to set up the committee and give a report as expeditiously as possible. That is my prayer also, my lord. Nothing,
Very well, I'll pass that.
yes, ma'am.
Despite service, none appears for the respondent. Full stop. The affidavit of service filed today be kept on record. Full stop. The limited prayer of the petitioner is that the petitioner, after having you lost your mother,
Yes.
after having lost his mother, allegedly to medical negligence at the at one of the hospitals of Kolkata, lodged a complaint with the State Consumer Disputes Redressal Commission, in connection with which an order was passed by the said commission, directing the superintendent of the SSKM hospital to form a committee/board on the subject and to examine the manner of treatment given to the patient and to ascertain the degree of negligence, if any, in the said treatment, and to submit a report before the commission within a period of 3 months from the date of the order. First up, it is noteworthy to mention that the said order was passed as long back as on May 20, 2022. First up, however, thereafter at least 4 further dates elapsed.
Five, my lord, 5.
At least I say.
I am sorry.
At least 4 further, including that 5.
Yes.
So
No,
4
after 20th May,
5.
the returnable date was 14th, and after that, even four more dates.
At least 4 further dates have elapsed, but without any formation of such board or any response on the part of the SSKM hospital. First up, the petitioner was constrained to give a demand for justice, also in vain. First up, next para, in view of the specific order of the State Consumer Disputes Redressal Commission dated May 20, 2022, as reiterated subsequently on several occasions, the respondent ought to have given formed such board and given a report by now. First up, accordingly, WPA 14472 of 2023 is allowed, thereby directing the superintendent, IPGME and R and SSKM hospital, to constitute a board/committee in terms of the order dated May 20, 2022, passed by the State Consumer Disputes Redressal Commission, West Bengal, in complaint case number CC stroke 29 stroke 2015, as expeditiously as possible, positively within 1 month from the date of communication of this order to the respondent. Full stop. Upon such formation stroke constitution of the committee stroke board, the said committee shall, upon conducting due inquiry in accordance with law, submit a report and furnish a report in that regard and intimate the interested parties in that regard as expeditiously thereafter as possible, preferably within 2 months after the formation of the said committee stroke board. Full stop. The direction passed on the respondent in the above regard is mandatory and peremptory, and the respondent shall act on the communication of the learned advocate for the petitioner, accompanied by a server copy of this order for the purpose of compliance, without insisting upon prior production of any certified copy of this order. No orders to cause urgent certified copies.
Grateful, my lord.
I'll come back in 10 minutes and take up the
সাথে
18.
I am for the petitioner, Lordship.
Yes.
Lordship, petitioner is a cultivator and applied for submersible pump, Lordship. Thereafter, no steps have been taken to give
Right.
connection, Lordship.
I am for the distribution license.
Yes. What happened?
My lord, the petitioner has applied. My lord, he was informed to my lord file submit my lord duly filled in application form. He submitted it on my lord 17th May. The matter has been 17th May. Writ petition has been filed on 14th June.
So you
Now,
process
my lord,
it
on
as
15th June,
Ah.
my lord, he has been given a letter intimating that your application form is not duly filled up and some documents are missing and required. Necessary documents are, my lord, lacking. That has been informed to you, to the petitioner, my lord.
Have you got a copy of that?
Yes, yes.
Lordship, this letter has been issued after affirmation of
After
the
affirmation.
So comply with this then.
Lordship.
Learned counsel for the petitioner submits that the petitioner seeks an electricity connection to operate his submersible pump, which has not yet been given by the WBACDCL. Full stop. Learned counsel for the WBACDCL contends that the petitioner initially had filed an application which was not in appropriate format. Full stop. Accordingly, comma, upon being intimated, comma, the petitioner filed a proper application on May 17, 2023. Full stop. Thereafter, a communication has been made to the petitioner by the WBACDCL on June 15, 2023, indicating that the application has not been filled up properly and certain documents are required to be handed over by the petitioner. Full stop. A copy of the said communication filed today be kept on record. Full stop. Accordingly, WPA 14487 of 2023 is disposed of by directing the petitioner to deposit the documents which are required by the WBACDCL in accordance with law within a week from date. Full stop. Upon such documents being handed over, comma, the WBACDCL shall process the
And also the my lord form. Form is not complete, my lord.
Acha, documents as well as a properly corrected application, properly filled up application, comma, upon which the WBACDCL shall raise estimates and upon compliance of all formalities by the petitioner shall give the electricity connection to the petitioner. Full stop. It is expected that in the event the petitioner files the application in proper format along with documents within a week from date, comma, the estimate shall be raised by the WBACDCL within a fortnight, within a week thereafter, and the connection shall be given, comma, if otherwise feasible, comma, within a fortnight from the date of compliance of all formalities by the petition.
Grateful.
No rest to cause urgency.
Great, great.
19.
I am for the petition, Lordship.
Yes.
I appear on behalf of the CS.
Lordship, petitioner is a tenant applied for electric connection.
Landlord served. You are appearing? Yes.
Applied for electric connection.
Resistance.
No, kindly come to page 10.
Let him submit. Yes.
CSC
Take
authority,
the mic, Vishal.
CSC authority came for inspection, Lordship. They carried out inspection, but during inspection, the landlady put strong objection against the said connection, and thereafter the CSC authority issued us letter, Lordship. Kindly sees the splitting of load later, Lordship. I have annexed, Lordship.
At page
Annexed at
10.
P2.
Is there any litigation pending with
No,
you?
no.
Strained relation otherwise?
Lordship.
Strained relation.
The relation is not good, Lordship.
Acha.
And
Yes, what do you say?
My lord, we have, according to my instruction, my lord, there is no resistance, my lord. We have inspected and we have issued a letter that is at page 10 on this ground of splitting of load because they are already deriving supply from the meter of Shormishta Shaha. Now let this matter be sent to the GRO, my lord.
No, splitting of load is not applicable here. There is obviously she's opposing. Yes, what is the ground of your opposing?
They already have a connection, my lord. They are wanting a new connection. This is what I'm opposing, my lord.
From you?
No, not from CS.
They have a. They already have a new have a connection in their name.
In sub-meter, my lord.
no, Lordship.
Submitted from your connection.
Deriving supply.
from their connection.
But
Lordship.
Mr. Halder, if there is no threat of disconnection, then where is the question of this?
Lordship, they are continuously threatening and they are taking excess bills from us every month. And Lordship, the three-bench
Then send it to the GRO.
and Lordship,
Learned counsel for the
three-bench judgment of our honorable court
There
has
is no
held
proceeding which has
held
been
that-
initiated either by
Three-bench
Mr.
says
Halder
what?
or by the
settled,
landlord.
has specifically held that Lordship, a person in settled possession of a property as illustrated in the case of Romegowda is free to apply of supply of electricity without without the consent of the owner of the same, and is entitled to get electricity and enjoy the same until he is evicted by due process of law.
Learned counsel for the petitioner submits that due to resistance by the landlady stroke private respondent number 4, comma, no electricity connection is being given to the petitioner at the premises where the petitioner is a tenant. Full stop next para, learned counsel appearing for the petitioner further submits that as per settled law, comma, any person in settled possession of a property is entitled to get electricity connection even without any no objection from the owner. Full stop as such, comma, the objection by the landlord need not come in the way of giving electricity supply to the petitioner. Full stop next para, learned counsel for the CAC Limited points out that the CAC Limited has, comma, upon inspection, comma, written to the petitioner, comma, which communication is also annexed at page 11 of the writ petition, comma, thereby apprehending splitting of consumption of units if a new connection is given, comma, since the petitioner is already enjoying electricity from his landlady. Full stop next para, learned counsel appearing for the respondent number 4 also submits that the petitioner is enjoying electricity from a submeter which is connected to the electricity supply of the landlady. Full stop as such, comma, there is no necessity for the petitioner to take a separate connection. Full stop next para. An arguable question has been raised in the present case as to whether there is an occasion of splitting of load, comma, since the petitioner is not suffering any immediate threat of eviction from the landlord and or disconnection, comma, at least as apparent from the records. Full stop. Since the competent authority under the law and the prevalent regulations is the grievance redressal officer to decide disputes as regards splitting of load, comma, it would only be prudent to relegate the matter to the said authority. Full stop. Accordingly, WPA 14491 of 2023 is disposed of by granting leave to the petitioner to approach the concerned grievance redressal officer with the dispute as raised in the present writ petition. Full stop. If so approached, the grievance redressal officer shall give an opportunity of hearing to the petitioner, the licensee, as well as the respondent number 4, and thereafter, comma, pass an order in that regard in accordance with law. Full stop. The entire exercise, comma, it is expected, comma, shall be concluded within 8 weeks from the date of communication of this order to the grievance redressal officer by the petitioner and the petitioner approaching the said grievance redressal officer. Full stop. Parties as well as all concerned shall act on a server copy of this order for the purpose of compliance. No rest to cause urgency.
And only one thing, Mana, instead of page 11, it will be page 10. The chitty tab, not a page 11.
Page 10, page 10. But
তার ওখানে ভুল দি কি করেছিস 11 দিকে
আমার ওখানে ভুল গেছে পেজ
Next one.
গ্রেটফুল
I'm grateful.
20.
Item number 20, Lordship, I'm for the petitioner. The service is not yet complete, so I'm praying for the 1 week time. So I'll
Learned
start
counsel
and
for
come
the petitioner seeks a week's adjournment since service is not yet complete on the respondents. Let the matter stand adjourned till the next monthly list. Yes. Call.
21.
I am for the petition.
for the state.
Right.
This is my service, my lord. Lord, the petitioner before Lordship, my lord, is the secretary of the Lord Jodhpur Idujha Utsav committee, my lord. He wants, my lord, permission from the authority concerned to Lord to enjoy the Lord Idujja Utsav on 29th. He made recommendation to the authority concerned, but they have not yet considered.
How do you want to celebrate that?
Celebrate Lord in the usual manner. What happened, Lord? The land has been Lord, the land where the Lord Idujja will be Lord performed, Lord. This is the petitioner is the secretary is the owner of that land. And Lord, as such, Lord, no objection is not required. And Lord, usually it was Lord, it will perform Lord earlier, but Lord, due to Lord COVID, Lord, it has been stopped Lord, for some years.
That permission is not being given.
Not being given, Lord.
Yes,
Lord,
what do you say?
Lord, kindly take up page 16. Lord, it's a bit sensitive issue. That is the only thing. And what they have applied, it is under process. My Lord, we have to ascertain what is the exact situation in the locality, my Lord. That is also very important. If your Lordship kindly takes up the page 16, first, sixth, second, third, fourth, fifth. My Lord, kindly see the fifth paragraph. In a place full covered and satisfied, make kurbani of the animals without hurting any person of other religion. My Lord, there is a performance which has to be done. My Lord, we have to ascertain the perspective, and Lordship knows.
When will you decide? When will you decide?
My Lord,
Because today we are on 23rd.
My Lord, yes, at least, my Lord, I cannot take up 7 days because that 7 days will be 29. But at least 5 days time. My Lord, in the meantime,
You need some time also to prepare for that. If you give them permission, they'll require some time to arrange that.
My Lord,
If you don't give permission,
yes,
that's a
it's-
different issue.
My Lord, that.
But if you give
depends-
permission, they require some
but
time. Do it by I'll give you 2 days. Do it by
2 days,
Monday.
my Lord,
3
today
days,
is
Monday.
Friday, my Lord. So at least till Monday.
Saturday, Sunday, the government works.
My Lord, that there we have to, my Lord.
I
At the
hope
same
it
time,
works.
Lordship knows now during the
Government
this
works during Saturdays and Sundays.
well, during election period when no Saturday, Sundays, well, 24 into 365, my Lord.
Do it by 26. This may also be helpful for your election purpose.
My Lord, we are on it already, but we have to take inspection of the local.
This is also covered by the election process. Permission for Idul Zoha is also covered by the election process.
My Lord,
This is also election activity.
let you dispose writing
The grievance of the petitioner is limited, full stop. It is submitted that the petitioners have applied for permission to observe the Idul Zoha, which is going to take place on
29.
June 29, 2023. Full stop. Next para, however, comma, the respondent authorities are sitting tight over the matter. Full stop. Next para, learned counsel appearing for the respondent authorities submits that since the issue is a bit sensitive, comma, touching religious sentiments, comma, the authorities are requiring some time to take a decision on the representation of the petitioner. First of that apart, comma, in view of the current panchayat elections, comma, all resources of the respondent authorities are engaged in the election process. First of next para, be that as it may, comma, since the petitioner cannot wait indefinitely for a decision on their representation, comma, keeping in view the impending date of the Idul Zoha, comma, the WPA 14625 of 2023 is disposed of by directing who has to take decision.
Respond 2, my Lord. Respond number 2.
Only
District
2,
magistrate.
not
Only-
6,
only-
7.
only-
These
Only 2. If it not to take decision,
the others.
then
Directing the respondent number 2 to decide on the representation given by the petitioner, comma, annexed.
P2, page 15.
Thank you. Annexed at page 15 within bracket annexed P2 bracket close to the present writ petition, comma, as expeditiously as possible, comma, positively by June 26, 2023, and to immediately intimate immediately thereafter the decisions so taken to the petitioner. Thank you. Do it by Monday, please. Then otherwise, it's very difficult.
Yes, yes.
They have only 2 days in the.
Oh, yes, my Lord.
Thank you. Next.
22.
22.
Make to appear on behalf of the respondent number 6. my lord.
Respondent. You are for the petitioner?
I am for the respondent, your lordship.
Mr. Bhattacharya, you're taking your time to come. Nothing in the matter. All have been served.
Yes.
What is the matter? Yes.
You know, there are
basically, the principal issue is inaction on the part of the competent authority to redress the grievances of the petitioners who are flat owners of this Uniworld city apartment, somewhere in Newtown. Now, the immediate grievance, which prompts me to, come to your lordship's court is conduct of an election, which is scheduled on Monday, on Sunday, by a notice, which was circulated sometime on the 12th, for which I have ventilated my grievance. First of all, the 12th notice says that the respondent number 6, DS law advisors, this notice is circulated quite late in the night. Immediately, everything was stage managed. Within maybe 12 hours or 15 hours, DS law runs into the show and takes steps, soliciting names and does everything.
What steps?
For the conduct of the election.
What DS law?
DS law.
What they? I mean, how are they connected with your apartment?
They are not connected.
Achha.
And interestingly, they have been appointed, on the intervention of the competent authority. That your lordship will be pleased to find from.
That shows the competence of the authority.
No, something more is much more than what meets the eyes, please see.
Yes.
Page 50 for a moment.
The middle name of respondent number 5 is deliberately being used.
Huh?
Middle name of respondent number 5 is deliberately being put there. The middle name of respondent number 5.
Just give me a moment. I don't know.
Anyway.
He is not the same person.
Obviously, that's why the middle name is very prominent.
Now, page 50.
50.
Apropos various complaints, the competent authority suddenly gets active, or rather, overactive, and at around 11:35 p.m.
You are for the authority.
No, I'm for the respondent number 6. DS
for
law
the
firm.
competent authority. You are appealing for the competent.
I have served the competent. Competent authority does not care. He has received notice. The government leader's office has received notice because he has his personal interest. I may say, my lord.
And the competent authority also. Competent authority has become untouchable, Mr. Bhattacharya. After
Because
you filed the
thinks what he has done, your lordship will be shocked. I'll just immediately say 11:35, this mail, asking, an intervention. Now, kindly sees, the name of this competent authority. It's appearing in the mail itself.
Competent authority?
Yes. Joint secretary just above him, the name. Kindly do not take the name. The name is here.
Who is he?
He is the competent authority.
I mean, who is this person? I don't know.
He has, intervened in the election process. My grievances, raised with the competent authority over the last, 4 or 5 months. The owner's grievances regarding financial mismanagement and everything is not heeded to. Suddenly, he triggers, an action is triggered from his end. And what the competent authority does is, he intervenes in the election process and somehow, manipulates on the board of management of this organization and ensures that this respondent number 6 is appointed to conduct the election. That your lordship will be pleased to find from a trail mail, on WhatsApp communication, which I have annexed, at page 62.
Yes, 60.
61 is important before that. This is 11th of June 2023. This is written to the members on behalf of Kolkata Uniworld City Apartment Owners Association. What does it say? Kindly sees. It is hereby notified that Apartment Owners Association, AOA, has appointed Measures DS Law Advisors as the third-party neutral agency for conducting election for the vacant position 17 numbers on behalf of this organization, respondent number 5 and 6, as decided at the AGM, the firm have conducted many elections on behalf of various AOAs across West Bengal. My lord, in the teeth of, my lord, paragraph 8 of the procedure, my lord, the relevant, my lord, bylaws now, my lord, which has been promulgated by the competent authority himself, my lord, this is completely without jurisdiction. Appointment of a third party agency, 1. Apart from that, my lord, kindly see 62. I could have understood, my lord, the AOA appointing this, the neutral agency. My lord, I take it, my lord, that they want to appoint a neutral agency. The previous election, my lord, incidentally, one of our honorable judges may not stay in the same apartment. It was at his ages, my lord, the election was conducted there. 62 kindly sees. Dear all, please note, this is the WhatsApp, my lord, circulated. My lord, I have somehow been able to lay my hands on, my lord, I cannot disclose the source. Please note that the third party neutral agency was appointed after consulting the CA for neutrality and credentials. The firm initially quoted a fees of rupees 100 per voter, which was around 2.97 lakhs. My lord, no tender, no invitation from anyone. Suddenly, my lord, 50,000 rupees has been sealed. The election process, my lord, will have to be conducted at an expense of 50,000. And apart from anything else, competent authority is personally interested. Why? That, my lord, I have pleaded that he has a vested interest because I did not have the relevant document. After the writ petition, what I find is this DS law firm, my lord, DS law firm is represented. Please see page 67 once. Kindly also sees the signature at 67. The first name, Diotima Shrestha Ghosh.
Wife?
No. Daughter. Daughter of the competent authority, my lord, that would appear from, my lord, this document.
You have averred in your writ petition. You have averred in your writ
Yes,
petition.
vested interest I have averred, not this. Please see the name. And my lord, kindly sees the signature also.
Yes, yes.
My lord, copy the other. Copy the Rudrajit. So if this is what the competent authority is up to, he has, my lord, virtually, he is incapable of acting. He is appointing his daughter's law firm to conduct election, to go into grievances.
Where is that bar, Mr. Bhattacharya?
My lord, kindly sees 8.
Bylaw 8, yes.
Please see, my lord, a boy. My lord, first is West Bengal apartment ownership bylaws.
Yes, I got it, yes.
Yes. Now, please see the notification first. The new one, 2022, your lordship is looking at.
2022.
Yes.
Yes.
Kindly sees, in exercise of powers conferred by 13(1) of the Apartment Ownership Act and with the prior approval of the state government, the competent authority, I'm sorry, my lord, the preamble, the first.
Competent authority in supersession.
In supersession of all bylaws, hereby makes the following bylaws. And my lord, kindly turns now to 8. This is how the election of managers take place. Within 15 days of formation of an association under bylaw 3, the apartment owner presiding over the general meeting referred to in the said clause shall serve notice upon each member of such association, fixing therein the date, not before 7 days, on which and the time and place at which a special general meeting shall be held for deciding the detailed manner in which and the date on which the election of the managers of the board be held. The election shall be held by secret ballot in accordance with the detailed manner decided under clause 1 by this bylaw. The service of the notice referred to in clause 1 shall be effected by personal service or through letter sent by registered post or through email or any other electronic mode after the managers of the board are elected as aforesaid. This is how the procedure goes on. It's in a meeting which is held, the procedure is earmarked, an election officer is appointed from amongst the members. Now, my lord, without resorting to anything, fundamentally, my lord, a competent authority, my lord, is not activated despite, my lord, giving him n number of grievances. Just a few matters back, my lord, I was in court in respect of another matter, my lord, complaints are lodged to him. He just remains mute. He does not, my lord, address anything. My lord, here, The competent authority has been informed about, my lord, construction endeavors being made inside, and the cost impact is 75 crores. I am not going into whether, my lord, it was right or wrong, it's a private thing. But the competent authority being an authority under the law, it is, my lord, kindly see section 16 now. My lord, first is, I invite my lord's kind attention. My lord, I invite my lord's kind attention to who is the competent authority, my lord, under section 3G. 3G. Competent authority means any person or any office. I'm sorry, my lord, has my lord very kindly got it? 3G.
Yeah,
Section
the Act.
Act. He is a creature of statute, my lord. He is bound by the provisions, my lord, enumerated in the statute. He
3G,
cannot go
yes.
beyond that.
Right. 3G.
My lord, competent authority means any person or any officer not below the rank of a deputy magistrate authorized by the state government by notification to perform functions of the competent authority under this act for such area as may be specified in the notification, and different persons or officers may be authorized for different persons, different functions or different areas. Now, here is a competent authority who has been informed about the various grievances. My lord, please see then, kindly comes to section 16B, capital B. Now, this is an amendment inserted sometime in 2003. I'm sorry, 1996. 1996. If the association of apartment owners having right to be exercised by the manager or the board of managers fails to perform its duty under this act or the bylaws made thereunder, the competent authority may give to it such directions as that authority considers fit. If the competent authority is of the opinion the function of the manager is detrimental to the interest, my lord, we have brought grievances. The grievances remain, my lord. He is maintaining, my lord, if I may use this word, my lord, stoic silence. He does not do anything. Suddenly he gets activated, my lord, when? On the 12th of June 2023 at 11:35 p.m. in the night. And prior thereto, my lord, on his intervention, my lord, this DS law is appointed to conduct election, and DS law does everything, my lord, in a whiff. And apart from anything else, my lord, he is a person interested. He is disentitled himself to even hold that post. He is, my lord, doing what? My lord, he is promoting his daughter's law firm. Unbelievable. If this is, my lord, no organization today, my lord, apart from the old housing complexes, my lord, in one of which I live, my lord, the new complexes, my lord, huge amount of monetary involvement is there. And therefore, my lord, this person has.
What was the person named? Page 50.
My lord, page 50. 50.
Yes.
As well as, my lord, 67 is the daughter's name.
No, the daughter is of the competent authority.
Yes.
And the manager is appointing that person.
My lord, the competent authority, manager is appointing no one. Manager is being appointed by internally from the association.
Here, page 61 says it is hereby notified that the AOA has appointed Messrs. DS Law Advisor.
Yes, yes.
So the AOA is not the competent authority.
AOA is not the competent authority, but it is on the competent authority's advice and intervention that this organization was picked up. My lord, it is like cherry picking, my lord, this organization. There is no procedure for. First of all, my lord, an outside agency cannot be appointed. Apart from the intervention of a court.
How do you prove the at least prima facie the involvement of the competent authority?
Yes, my lord, page 62.
62 is a WhatsApp.
Is a WhatsApp communication, internal communication.
By whom to whom?
By, you know, this is by the, I am told by the secretary of this organization.
Yes, to?
You know, to all, to whoever he is sending it.
So how does the competent authority come in?
Please note that the third party neutral agency was appointed after consulting the CA.
Achha.
For neutrality and credentials. And the CA has completely, my lord, he is not, if I may say so with greatest of respect, I've got nothing personal. He's a deputy secretary or joint secretary rank officer. But he is, my lord, personally interested in ensuring that his My lord, some
So, but this is a bit far-fetched because his daughter, yes, I can appreciate the competent
owner's
authority.
election.
The competent authority's daughter is a part of a firm or the head of a firm even. Suppose that be so.
Yes.
So she may very well be, but how that does it vitiate the managers? I mean, involvement.
My lord,
How does it
how it vitiates?
attract the
because-
managers
Because
involved?
it vitiates that the competent authorities, first of all, it's not within its domain or jurisdiction to recommend names.
Yes.
Apart from it,
No, he
my lord,
was consulted.
he was consulted. He says
He did not recommend.
he consulted. My lord, this
And
consultation
he does
also.
not admit this. The competent authority does not admit it. This may very well be the imagination of the secretary also.
Maybe.
Theoretically, it
but
may
the
be.
fact
So how do
remains-
we
but the
bind the
fact remains
competent
may not-
authority?
The fact remains, my lord, 2 + 2 becomes 4, not 5, because my lord, the
Depending on the axioms.
my lord, the thing is,
If in binary it's different,
maybe true.
may not be.
But the
5.
fact remains, my lord, the competent authority, after consultation, is recommending the name of a law firm of which
How
my
do
lord
we
is-
know that the secretary's communication to all the members that the competent secretary, the competent authority was consulted? If I say that the Chief Justice was consulted, does that mean that the Chief Justice is involved?
My lord,
Or
I am
whoever,
not
the
involved.
President?
I am not saying involved. When I am lodging complaints, the competent authority does not get active.
Competent authority's involvement does not appear here from anywhere. Yes, you may say he was inactive on the complaints lodged by you. That's a different cause of action.
But my lord, at the same time, my lord, let us not go to the extent of blaming. But the fact remains, this outside agency could not have
No,
been
even if
appointed.
there is an apprehension, Mr. Bhattacharya, no question of blaming. Even if there is an apprehension of foul play, definitely we
But
can interfere.
there is an apparent apprehension. You know, on
The
the face of
secretary
it.
communicates that I have consulted the competent
Yes.
authority.
So therefore, my lord, what happens is a reasonable apprehension of my lord interest is involved. But somewhere, my lord, it's not the question of my lord bias
Competent
only.
authority's daughter may be a competent lawyer also.
Maybe undoubtedly so.
Where is the
My lord,
difficulty?
the question is, my lord, a law firm. This is not a my lord, election is not the my lord, the function of a law firm. Assuming my lord, the law firm, his daughter is not there, no one is
Can
there.
decide on an election, a law firm can decide on that also.
Anyway, my lord, I accept, my lord, whatever is falling from your lordship, but the fact remains.
Lawyers and judges are expert of all experts.
My lord, undoubtedly
You're supposed
true,
to be.
undoubtedly true.
That
But
is
this
a-
person, my lord, has completely disentitled himself.
Why interfere with the internal matters of the
My lord, if your lordship prima facie feels that your lordship, this sort of a proceeding does not worth your lordship's attention or my lord, does not deserve, my lord, I cannot say anything.
Apart
But
from
I am just,
apart from 50,000 and 2.97 lakh, nothing
my lord,
attracts my
50,000 is also without any meeting, without any invitation. Why my lord DS law? Why not my lord any other law firm or any other individual?
discretion of the president secretary.
My lord, there is no question of discretion. He is my lord there. He is acting my lord on the basis of these bylaws.
So are you trying to say that the election is vitiated by this?
Yes, yes. Let the election take place in accordance with paragraph 8. I am not, my lord, I am not shirking from election, and let the competent
Is there
authority.
any specific allegation against DS law?
My lord, DS
Yes,
law.
you're wanting to shunt out DS law only. Your
DS
ultimate
law,
purpose is to do
your,
that.
your lordship,
Why?
your lordship may appoint anyone.
No, Mr. Bhattacharya, you have got allegations against the manager. What the secretary is doing is that the manager is being shunted and DS law is being put in.
My lord, my allegation is that the procedure enumerated in the West Bengal Apartment Ownership Act rules and bylaws
That
is
is on
being given a
theory.
go by.
But in practicality, Mr. Bhattacharya, you have allegations against the manager, you approach the competent authority on that. Now that is pending.
Yes, allegations against the functioning of this organization. Of the
manager.
Of not only the manager, the president, the secretary, everyone.
All right.
My lord, they are doing things, my lord, which is, my lord,
Election is not vitiated, Mr.
my lord,
Why do you
election
say
is taking place day after tomorrow. If this election is permitted to hold, my lord, on the basis of DS law's involvement, my lord, then, my lord, it perhaps gets vitiated because in the light of, my lord, paragraph.
that is an apprehension without any basis? I mean, DS law, what is the allegation? Is apart from
DS
a
law,
daughter of the competent authority being a part
your
of
lordship
it?
feels that the competent authority sitting in the chair is going to promote, you know,
Not promoted.
He is.
The secretary has that. There's a distinction between the two. The secretary, the competent authority have shown nothing to say that the competent authority has actually recommended. The president, the secretary, against whom you have allegations that he is mismanaging, that mismanaging secretary, according to you, that person says to all the members that I have consulted the competent authority and therefore I am appointing this person, this DS law.
Grateful to your lordship.
So that he says. Now, even if he says that, you have allegations against this person also, the secretary also. Has
Yes,
to say.
for financial mismanagement.
For whatever reasons.
Not for
So
which,
this
my lord,
person
he
is
is
quoting the
maintained-
competent authority to say that I have consulted with the competent. Where is the veracity?
The
Where is the
competent
basis of
authority
veracity?
is turning a deaf ear to my repeated pleas. I have
You cannot
repeatedly.
connect the two, Mr.
Milord,
Bhattacharya.
connection is, I could have, come to your lordship in a usual writ petition saying that the competent authority be directed to dispose of my representations after giving an opportunity of hearing. That would have been usual. The fact remains, when this fact came to light and this involvement of this outside agency came to light, this involvement of outside agency is completely without jurisdiction. Apart from it, the competent authority cannot give a stamp of approval to this. Consultation, no consultation. When it is being brought to your lordship's kind notice.
If there is anything vitiates the election, then approach the competent authority.
There's no question of the competent authorities. The
But-
question
or challenge
is not
that-
vitiated.
Challenge that
The
election.
question is, if it is an action which is inherently
Premature,
lacking,
sir.
in jurisdiction.
Why do you say that?
Of a third party agency is not contemplated in the law.
So it boils down to bylaw 8 interpretation.
Yes. Involvement of a third party agency, apart from who the agency is, which the agency is, or even an outsider, is ruled out. The election ordinarily takes place from amongst the members by appointment of the
DS law will obviously follow the bylaws. In terms of the bylaws, DS law can conduct it.
If today DS law will follow the bylaws is one thing, but DS law has got nothing to do with this organization. It is, extracting some revenue for its own benefit for conduct of the election, which, in my most respectful
I understand your allegation. The underlying theme is that because your allegations are pending before the competent authority, this person, this present management, they are trying to involve his daughter so that he gets specified and all these things. So that's the underlying undercurrent of you. Yes, that undercurrent can be reduced.
No, it will not.
Just because his daughter's farm has been.
Ignore that. Kindly for a moment.
Whom should I ignore? The daughter or the father?
Ignore that, for a moment. What I am respectfully submitting to your lordship is,
yes,
kindly, the law does not prescribe involvement of any third party agency.
Section
for
8.
conduct
Section
of
8
election.
has to be interpreted. Yes.
It does not involve the involvement of a third party agency. It is incidental. That, the daughter's law firm has been involved, on the consultation, with the blessings of the competent authority, rightly, wrongly. It is just incidental. But the fact remains, my fundamental issue is, this inherent lack of jurisdiction on the part of DS law, or for that matter, any third party, to conduct this election on behalf of the association. That is the inherent.
Let us hear them now. You are for which respondent?
Respondent number 6, my lord.
Who are you?
DS law firm. DS law firm.
DS law firm, yes.
My lord, with all due respect, I submit. Just because, if I consider, just because my father is a competent authority, is there any embargo upon me to run a law firm? Or is there any embargo to conducting the, professing the legal profession?
No, there may be certain apprehensions in this particular context
But-
because
but my lord,
allegations are pending against this present management before the competent authority.
my
And
lord,
his
the-
daughter firm is appointed as a.
But the allegations, my lord, made by the petitioners are indeed grave in nature. And my lord, the dispute is absolutely between the owners and board of managers. Absolutely an internal dispute. I am being appointed. By
You're appointed, sanctioned by bylaw 8.
my lord,
What
that
was
was
that?
that was approved by the secretary.
May I? No, even if it is approved by the secretary,
Yes.
that has been challenged here.
Yes, absolutely. It's in challenge, but my lord, that is absolutely an internal dispute. I am being appointed. I am representing just because I'm appointed in respect of something. Now, my lord, if I am being.
I hope the daughter of the competent authority has not signed your vokalatnama.
No, my lord.
Yes.
I am for the association, your lordship.
I get your point. Please take your seat. Yes.
My lord.
Lordship may kindly take bylaws 8. 8.1. Once the association is formed, under 8.1, the first board of managers are to be appointed. Following 8.1. Lordship will kindly take 8.6. All subsequent elections of the managers of the board shall be held in the manner as decided under clause 1 of this bylaw or in any other manner as will be decided by the association in a subsequent general meeting. All subsequent election of managers of the board shall be conducted in the month of May. Now, the thing which has been first suppressed, The AGM was held on 20th of May. First, 21st, then it was adjourned to 28th of May. As per the bylaws. May I hand over a copy of the AGM? This
Give
is
a copy
the
to him
minutes.
Give a copy to them also. Yes.
The question today I am on the question of appointment of DS law.
That was sanctioned by this AGM.
Right. Agenda 6, if your lordship kindly takes.
So 6 is your lucky number. Subsection 6, agenda 6. Anyway, 6, what does it
To
say?
consider the manner and date on which the election will be conducted through secret ballot for filling up the vacancies, 16 numbers to the Board of Manager as per amended West Bengal Apartment Owners Act 1972 as on 6th April. On this agenda, it was proposed that the election is to be held on 25th June. So first, on AGM, on 20th of May, they knew that the election is going to be held on 25th of June. As per available vacancy, which is 17 at present, and members approve the date of election. It was thereafter proposed the members choose and decide whether the election is to be held physically or online or hybrid through secret ballot. Because post-COVID, your lordship knows, most of these apartments are holding the elections through secret. Majority members voted for hybrid mode, and hence it was resolved that the elections be conducted simultaneously through hybrid online physical voting mode, ensuring secrecy. It was further proposed that the election be conducted through a third-party neutral agency to be appointed by the Board of Managers, and this was approved by the majority of the members. This has not been annexed to the writ petition.
Why the law firm?
Your lordship,
particular law firm
no,
which has
it's not about the daughter and the father and the daughter thing. DS Law has been handling these kind of election and is reputed for handling, which I am told, like they have handled the elections of South City and other elections. Because of their expertise, they were appointed. They were negotiated and they were appointed. It's not about the daughter, father, and any reference being there or any suggestion came from the competent authority.
No, your WhatsApp. What about the WhatsApp?
It was a consultation that whether
Your daughter should be appointed.
Whether a third party neutral, it doesn't say the law firm. If your lordship sees the WhatsApp, that is the writ petition is on another grounds. The argument today is made on page 62. Competent please note, third party neutral agency was appointed after consulting the CA for neutrality and credentials.
Right.
And
third party was not decided.
No, they say Mr.
No, that's yes, I get your point.
Lordship.
So neutrality was only decided in that
Right.
consultation according to the
Right. So they, and if your lordship says bylaw 16, there is a grievance redressal forum. They have not gone there. They say that there's no, in the writ petition, they say there's no grievance redressal forum. There is a forum. All the forms are there circulated with all the apartments. They don't go there. They choose to come here. Why this proceeding today is motivated? Lordship will take the lordship will take the name of the writ petitioner number 1 first.
Yes.
Lordship will kindly come to page 68. There were 17 seats in total. This was the list prepared by DS Law. Today, why this writ petition? 17 June, this list came out. Lordship will turn to 69. This was suppressed. This ought to have been coming from the petitioners while they were addressing. In continuation, first is the list of the candidates who have submitted within time. Next page. In continuation of this candidate list, we have received a nomination at 20:04 on 16 June 17, 2023 from Mr. Anirban Rai Chaudhary, one of the member of Kolkata University Apartments having apartment number so and so. As per him, he sent the mail at 1958 hours, but due to internet lag, there was a delay in delivery. This matter is subject to investigation from our side. The final decision will be informed to all the members in due course of time. He was given an opportunity to come and represent. He didn't appear. So his candidature was cancelled. Then the final list of the remaining candidates of the election, which is going to be held on 25th, was published. That is at 70. Now, the petitioner number 2, my lord will see, he is a defaulter of the common area maintenance. And and he writes the mail to this association that you are doing excellent job. And today he's coming and complaining. Lordship will kindly see the 17 June mail. 17 June, the bottom. May I hand over? Dear Mr. President, I hope you are doing well. At the onset, I would like to congratulate you for the wonderful work done by your team in initiating the formation of subcommittees. I am sure more participation from residents is absolutely essential to ensure UWC is well managed and taken care of while putting the interest of residents before all. Before self. I'm sorry.
No, this was just nicety. With
So
a touch
on
of sarcasm.
17 June,
With a touch of sarcasm. No. The next questions are make it very clear.
Huh.
So he makes the questions, puts the questions. Before that,
No,
he says,
and the
you are doing very well. I'm
Revan's
sure you're doing.
forum is there. The other issues in the rate are with regard to the accounts and all were finalized. We came in July, which is admitted from the writ petition only. The previous management has not given their accounts has not been done. The AGM was not conducted due to COVID. We have conducted the COVID.
You know, let us not
everything.
go into
So
that.
I'm not going into the merit.
The present.
The only thing, the election is on 25th. The law does not bar appointment of a third-party neutral agency. That was confirmed by the board of members and in the AGM, which was approved by all the majority members.
Let me hear, Mr. Secretary. Yes. What reply? Short
Or if
reply.
your lordship deems, let a special officer be appointed for supervising. Let DS law, since they are conducting, they are into. Let a special officer be there as supervisor. We are agreeable to it.
Which special officer?
Any
Why?
of your any
There is
any
no scope of
advocate of your,
interference.
if your lordship.
No, Mr. Bhattacharya, there is no scope of interference.
Neutral person be appointed. You know, how can?
How do you know DS law is not neutral? That is the difficulty. Why remove a that will be a stigma also unnecessary.
N number of complaints with the competent authority. He has remained inactive all this time. He becomes active on the 12th of June. That too at the dead of the night.
So you have already paid DS law.
Your lordship, the initial sum payment has been made to them.
That
They
will
have
go to
arranged,
waste.
they have been active for this election from the day they were appointed.
So now at this juncture, it
At
is
a,
removed.
day after
appointment
tomorrow
is
is a Saturday.
With
So that's
respect,
why I was saying, if your
with
lordship
respect,
feels
a
a supervisor, the only.
Mr. Bhattacharya, no scope of interference.
With respect, 61 is the document 11th of June that we are informed about the involvement of DS law. And it's very easy to say that the WhatsApp communication only regarding neutrality, but please note that the third party neutral agency was appointed. So this third party neutral agency's appointment, the name of this third party neutral agency must have been received from the competent authority. And the competent authority must have disclosed the name. It is very easy to say that it is expert in that field. I will only bow down to this, whatever election can take place, let it take place on the basis of whatever papers, whatever nominations received. But kindly involve some other person apart from this.
At this juncture, if somebody else goes to the hymn, how will he conduct? Or she conduct? Today we are on 23rd, Mr. Bhattacharya.
It is just filling up vacancies. There are total 48 board managers, out of which 17 vacancies are to be filled up. Your lordship may
DS laws functions, if you are aggrieved with that, you have your forum for scrutinizing that.
The thing is, I question.
Approach under section 16, or you can also go to.
I have been approaching under section 16 from since 2020.
Why didn't you file a writ petition simply for for a direction?
I could have.
On the competent authority to decide on that.
I could have.
You never did
Your
that.
lordship is correct.
You woke up after this election was scheduled.
I woke up after page 61, 62.
This ipso facto does not vitiate the election.
Lordship feels I cannot say anything.
Yes, Ashwin.
Please see page 78 once. We have written to the CA also. On June 21.
Saying what?
I am forwarding a trailing mail. The owners of Google Group, the mail, how the elections for the vacant 17 posts are being conducted in an irregular manner. The board is deliberately acting in a manner detrimental. Now, to the interest of the apartment owners, there are several irregularities in the conduct of elections and the voter list prepared by the board.
No. Learned counsel for the petitioner vociferously argues that patent irregularities have been committed in declaring the elections of the Kolkata Uniworld City Apartment Owners Association on June 25, 2023. It is argued that despite several complaints against the present management of the said association pending at the behest of the petitioners before the competent authority, the said authority has been sitting tight over the matter. Next para. In the meantime, by a communication dated June 11, 2023, comma, the present management intimated the members of the association about the appointment of one Messrs. D.S. Law Advisors, comma, also a respondent herein, comma, as a third party within double inverted neutral agency, double inverted clause, for conducting election for the vacant positions on behalf of the association as decided at the AGM. Full stop. Next para, learned counsel places reliance on annexure P12 at page 62 of the writ petition, comma, which is purportedly the transcription of a WhatsApp communication by the present secretary of the association to members thereof, comma, indicating that the third party neutral agency was appointed within double inverted after consulting the CA ta capital, double inverted clause, for neutrality and credentials. Full stop. Next para. Thereafter, the costs to be incurred for appointment of the said firm was also mentioned. Full stop. Next para. It is argued by placing reliance on certain documents handed over by learned counsel for the petitioner, comma, that the daughter of the person in charge as the competent authority is one of the active. She's a partner, Mr. Bhattacharya. What is she?
Partner.
Is one of the active
No, no,
partners.
Yes, partner. My lord, kindly, your lordship is not minded to interfere with, but regarding the other grievances, my lord, regarding his inaction, my lord, kindly dispose.
Have you made that prayer also?
Yes, yes.
Partners of the said Messrs. DS Law na ki bollam? DS Law. Pushed up as such, comma, it is apprehended that the said specific firm has been appointed in order to appease the competent authority, comma, which is, comma, incidentally, comma, also sitting tight over the complaints of the petitioner.
There E.
Full stop. Next para. It is further argued that when the competent authority was sought to be contacted by the members of the association, comma, the competent authority refused to interfere on the ground that he does not stay in the Uniworld city, comma, that is the concerned housing estate, comma, and cannot check tower notice board. Pushed up. Next para. However, comma, he reiterated that it does not take away his right to receive election notices and nominate himself as a candidate as per the AOA Act. Full stop. Next para. The same, comma, it is seen, comma, is a trail mail annexed to the writ petition. Full stop. Be that as it may, comma, learned counsel for the petitioner also alleges that the provisions of bylaw 8 of the West Bengal Apartment Ownership Bylaws, 2022 has been patently contravened by appointing a third party as the authority to conduct the elections. Full stop. Such empowerment is entirely dehors the provisions of the bylaws of 2022. It is submitted. Full stop. That apart, comma, learned counsel also submits that the said appointment is entirely beyond the scheme of the West Bengal Apartment Ownership Act, 1972, as well as the bylaws. Full stop. Next para. Learned counsel appearing for the respondent number 6, oblique DS Law submits that the mere incidental fact that one of the partners of the said firm is the daughter of the competent authority has no connection with the dispute raised by the petitioners. Full stop. That apart, comma, in the absence of any specific allegation against Messrs. DS Law otherwise, comma, it would be beyond the scope of the present writ petition to remove the said association, said law firm. Full stop. Next para, learned counsel appearing for the association submits that the appointment of DS Law was not out of the blue, but done with the sanction of the majority of members of the association
That I dispute.
who attended an annual general meeting of the association and took the decision of appointment of a third party under the aegis of the board of managers. Next para, learned counsel for the respondent stroke association also hands over a purported copy of the minutes of the said meeting to the court, which is, however, disputed by learned counsel for the petitioner. Next para, it is further argued by the respondent stroke association that in terms of bylaw
8.6, your lordship.
yes, just let me find. Bylaw 8 within bracket 6 of the 2022 bylaws, all subsequent elections after the first election of the managers of the board shall be held in the manner as decided under clause 1 of the bylaw, double inverted tarpor, or in any other manner as will be decided by the association in a subsequent general meeting, double inverted clause. Next para, hence, there is no bar in a third party neutral agency being appointed as enough to conduct the said elections. Next para, moreover, there is no irregularity in the mode of appointment of the said firm, since the said firm is reputed for having conducted similar elections in respect of other large associations, which is, of course, also disputed by the petitioner. Next para. It is thus argued that the
Firm's reputation is from 2022. She was enrolled in 2022.
no, she might have been enrolled. That all the more shows that before her the firm was functioning.
It
That
shows
goes against
much
you.
more than what meets the eyes.
No,
With due respect,
Mr. Bhattacharya, it shows that her joining in 2022 is your ground, but the firm was functioning from much prior to that. That is what is shown. So that goes against you.
the firm was, let us not go into it. The firm is only functioning from 2020.
That the the purported WhatsApp message from the secretary does not vitiate the appointment of the third party agency, since the consultation referred to therein was at the most in respect of neutrality and credentials for the appointment of a neutral agency. Next para, learned counsel for the petitioner contends that disputes such contentions and submits that it is evident from the language of the purported WhatsApp communication that the consultation with the competent authority was in respect of neutrality and credentials of the particular agency appointed, which all the more shows that there was patent bias in such selection. Next para. At this juncture, learned counsel for the respondent association, on instruction submits that on principle, the said respondent does not have any objection if the court appoints a third party to conduct the elections.
No, your lordship, I suggested that let there was a special officer or someone along with the DS law, not a third
You did
party.
not say that along with
Yes,
this.
yes.
No.
Let DS law conducted with
No,
the
you did
thing.
not say that.
Yes, that was my intention.
DS law, you did not say.
No, in presence of them. In fact, that was the intention of Mr. Bhattacharya also.
However, at the juncture when the order is being passed, it is sought to be clarified by learned counsel for the respondent association that such concession was given to the limited extent that such third party special officer shall act in conjunction with DS law. Next para. Upon hearing learned counsel for the parties, comma, it is seen that the pivot of the arguments of the petitioner for the purpose of vitiating the appointment of respondent number 6 is that one of the partners of the respondent number 6 is the daughter of the competent authority. Full stop, next para. However, comma, it would be premature at this juncture, comma, merely due to such coincidence, comma, to hold that the credentials and neutrality of the said respondent number 6 is at stake. Full stop. Next para. It may very well be that the daughter of the person functioning as a competent authority is one of the members of the agency, comma, which has been appointed. Full stop. However, comma, it is argued by the respondent association on the strength of a document handed over in court today, comma, that a resolution was duly taken in terms of the bylaws by the in the annual general meeting by the majority of members represented therein, comma, that a neutral agency would be appointed for the purpose of conducting the elections by the board of managers. Full stop. In fact, comma, the same is also recorded in the said minutes, which have also been kept on record. Full stop. Next para. Even taking into consideration that the minutes themselves are disputed by the petitioners, comma, it cannot be said that per se, comma, the appointment of a third party to conduct elections is violative of bylaw 8 of the 2022 bylaws. Full stop. As rightly argued by the respondent stroke association, comma, subclause 6 of bylaw 8 clearly stipulates that for subsequent elections, comma, as in the present case, comma, the same shall be held in the manner as decided under clause 1 of the bylaw within double inverted or in any other manner as will be decided by the association in a subsequent general meeting. Double inverted clause, full stop. Such clause has been substantially complied with in the present case as per the association. Full stop. Hence, comma, the perception that such bylaw has not been complied with cannot be drawn at this juncture, comma, in the absence of specific evidence to substantiate such allegation. Full stop. As such, comma, it cannot be said that the appointment of respondent number 6 by itself vitiates the election which has been declared to be held on the coming 25th of this month. Full stop. Next para. Insofar as the appointment of a third party special officer is concerned, comma, the same would not improve the situation insofar as either of the parties are concerned, comma, since the respondent number 6 has already been entrusted to conduct the elections and has proceeded substantially in that regard. Full stop. The elections are due to be held only 2 days hereafter, comma, which is also another consideration.
Only one submission. Out of the 17 board managers, 14 have already been elected unopposed. It's only balance of 3 persons.
Whatever. For in the above regard. Full stop. Next para. Hence, comma, it cannot be found prima facie, even prima facie from the materials annexed to the writ petition that the election process itself is vitiated in any manner for contravention of the bylaw or on any other premise. Full stop. Next para. However, comma, needless to say, comma, nothing in this order shall preclude the petitioners and or any other members of the association, comma, if aggrieved by the process in which the election is actually held, comma, to ventilate their grievances before the appropriate authority in due process of law. Full stop. Next para. Insofar as the pending allegations and complaints made by the petitioners before the competent authority, comma, the competent authority, that is respondent number 2, is hereby directed to decide on the said complaints as expeditiously as possible, comma, upon holding an appropriate inquiry, comma, positively within 1 month. The competent authority is not represented here.
No, your lordship.
Within 1 month, within 1 month from the communication of this order to the said respondent. First up, WPA 14867 of 2023 is, comma, accordingly, comma, disposed of in the light of the above observations.
No observations made in the
Not
court expense, may not, the competent authority may not deliberately contrive not to hear me. Because
আর
I have
একটা
got
line-
allegations
একটা
regarding
line add
me,
করে দিন।
daughter, everything.
It is further clarified that none of the observations made herein, comma, which have been arrived at only for the limited purpose of deciding their present writ petition, comma, shall prejudice or influence the competent authority or any other forum in deciding any dispute pertaining to the association in question in any manner whatsoever, and the competent authority and all other legal forums shall decide all questions and disputes raised before them independently and in accordance with law without being influenced in any manner by any of the observations made here. Happy?
And item number 1 is not on
Deeply
server.
Item number 1 is
Judgment. It's not on server.
because I could not rise in the meantime. I'll sign it and immediately it will be on the server.
Yes, a reminder. Oblige.
Within a period of
1 month.
Grateful to you.
Saving grace.
Deeply.
Sure.
Upgraded matter item 23.
Should I appear for the petition as well?
My lord,
This is a matter where.
Learned AG is appearing for the state.
Pardon?
Learned AG and Mr. Shantanu Mitra is appearing for the state. He's on his legs.
Let them come, I'll start the matter. Yes.
Lord, in this matter, the 4 petitioners who has approached your lordships.
Your lordship, Lord's advocation is appearing. My lord, he is engaged in court number 5, my lord, and he was there before the recess.
Oh,
So kindly, my lord, takes it up.
is there any urgency? It cannot. What is
can
the
wait.
matter?
Without any notice, suddenly this matter has been upgraded. My lord.
Lord, this, your lordship, maybe I'll not stand in the way of an adjournment, my lord. But my lord, let it at least retain its position in the list, or maybe if your lordship says please to take it up half an hour hence.
Monday, my lord, I am not available. This Monday, my lord, next Monday.
The petitioners who have served sentences, they are kept in prison for 4 years, last 4 years, in transgression of laws. That is my case.
Subject to your lordship kind convenience, your lordship kindly fixes it on Wednesday and or Thursday, my lord.
No. These people are suffering in prison. They're behind bars.
My lord, I am
Under
not-
which act?
They were first my lord, convicted under Foreigners Act. They are
People
minors.
are unnecessarily suffering.
Yes.
Lord,
This cannot wait till Wednesday. Today, come back after 15 minutes.
Lord's advocate general, my lord, is not available.
You are there.
No, my lord, I am led by him, my lord, he should.
No, it's extremely urgent. I mean, these people are behind the bars. We have to hear it out at least.
Kindly takes it out. They are not behind the bar. They are housed in the safe house within the correctional home.
Safe house is worse than prison.
Inside prison.
You know the situation in safe houses.
My lord, respective sentences, now, my lord, they have been housed in a, my lord, a safe house within the.
The shelter homes are worse than prisons sometimes. Have you gone to any of these? I've been. That's why I'm saying.
Kindly takes it on Wednesday.
Wednesday is too late.
Wednesday.
Monday?
Monday, I am not available. My lord, Tuesday, Lord's AG is not
No,
available.
on the last occasion also you said the same thing. Just before Justice Bhattacharya also 30th February, this time was taken by the state.
Mr. Trivedi is appearing for the union.
No, not.
Lord, kindly takes it down on Wednesday. Subject to your lordship convenience.
An adjournment is sought by the state as well as the Union of India. Full stop. Let the matter stand adjourned and shall next be listed at the top of the list on June 20. Today we are here. June 28, 2023. Wednesday at the top.
Extremely grateful, my lord.
Thank you.
Grateful, your lordship. Thank you. Come.
Please ensure that Mr. Trivedi or somebody else is there on Wednesday at the top.
24.
I'm for the petitioner, Lordship. Lordship, on the last occasion, Mrs. Alam asked for an
Oh,
instruction. Yes, Lordship.
Yes.
Lordship, in the morning she was there, Lordship. Lordship, before starting, I want to pray for some true indulgence, Lordship. There, I have filed a CAN application, Lordship. Actually, in the main writ petition, there was a typographical error. Actually, the petitioner, while going to Rome from Kolkata, his passport was seized. That was
Acha.
mistakenly then that while coming to Kolkata from Rome. That
the other way.
yes, Lordship. For that, I have filed a
That application
CAN.
has been filed.
Yes, Lordship, that is filed, Lordship.
Appear করছে? It is
Yes,
appearing
Lordship.
also.
Yes, Lordship. And in the cause title, respondent number 5's name, it will be assistant foreigners. Up to that is okay. Regional registration officer, that portion is missed out. Yeah, respondent number 5. In the representation that was there, page 2. That I pray for a leave to correct that.
Leave to correct the cause title of the writ petition and to incorporate this in the writ petition.
Yes, Lordship.
This
And
none appears for the respondent. Full stop. However, comma in view of the
Lordship, can it be pass over because there is an
The application I'll allow.
Yes,
Only the application and this leave I'll give you. Do that. I'll take it up on Monday.
Yes, Lordship.
None appears for the respondent at the time of call. Full stop. However, comma, due to the innocuous prayers made at this juncture, comma, further adjournment is not granted for the hearing of the application. Full stop. Next para. Can 1 of 2023 has been passed, has been filed for effecting a necessary correction of typographical errors as mentioned in paragraph number 2 of the said application insofar as comma,
Paragraph number 2 and paragraph number 11.
in place of within double inverted coming to Kolkata from Rome, double inverted close, it was to be printed within double inverted going to Rome from Kolkata, double inverted close, full stop. Let the writ petition stand.
Lordship, and paragraph number 11.
Oh, acha, acha.
Next page.
Full stop. The
From-
next para arekta iye
Return-
another correction sought is in similar tune to the effect that the petitioner was returning from Rome, comma, Italy via Dubai instead of returning to Rome, comma, Italy via Dubai. Full stop. Next para. Let such amendments, comma, as sought in paragraph numbers 2 and 3 of Can 1 of 2023 be deemed to stand incorporated in the writ petition itself. Full stop. Next para. Can 1 of 2023 is disposed of accordingly. Full stop. On the prayer of the petitioners, comma, the learned advocate and record for the petitioner is given liberty to correct the cause title of the writ petition as sought for during the course of the day. Full stop. The writ petition shall be taken up for hearing on June 26, 2023.
It should be written in same position.
No, not necessarily.
Lordship, there is an urgency, Lordship.
No, even then.
Lordship, actually on the last.
How can
page,
I assure it will retain its position? There will be other matters also.
Lordship, actually there is an urgency. It was filed in 2020, Lordship, and his citizenship card will expire, Lordship.
Let us see, yes.
That's why the Lordship kindly.
25.
Actually,
I'm appealing for the respondent bank. Your
Yes,
Lordship.
yes, Mr. Shah, you have.
Lordship, may I indicate only one thing? My lord, the matter was mentioned on 19th.
No, sir.
My lord, the matter was mentioned on 19th. We have been served with a copy of the notice just yesterday. Mr. Sharmrat,
5 times they took extension to file. the
my
affidavit.
lord can see from the order that we have filed our affidavit.
In Singapore, this is another case, my lord, where they have issued the lookout notice, and my lord, they've stopped me from boarding a flight on the basis that I have some dues to the bank. Enough is enough, my lord. This cannot be countenanced forever.
My
I
lord,
made
the
an
application,
which I've served on them, saying that my sister is on her deathbed with cancer in Singapore. I need to travel urgently.
my lord, this is a case of the lookout circular. My lord, the application has been,
What is the can for, Mr. Shah?
That is, my lord, because my sister was unwell, my lord, I needed to travel. I was not being able to, I tell you, Lordship, what happened in this matter. When I boarded the flight, I was, my lord, deplaned. I boarded a flight to Bangladesh, my lord, in May last year.
So this can will suffice for the time being, if this relief is granted.
my lord, if this relief is granted, the relief of the entire, the writ petition will be allowed, your lordship.
LOC has been challenged. Lookout circular without cancelling the lookout circular also on undertaking. She may be.
My lord, there is no prayer for cancellation of the lookout circular. My lord can see from the
No,
writ
my lord,
petition itself.
let me, my lord, let me tell, my lord, tell you, Lordship, what the why, my lord, the prayers are in the manner that they are. My lord, when I boarded the flight in May last year, I was, my lord, deplaned by the customs authorities. Therefore, my lord, your lordship will see that the original, in the original writ petition, the customs were, my lord, made parties. I was taken down, my lord, from the flight. I was kept, my lord, in the hold area, my lord, for about 3 hours. And after I had been kept in the hold area for 3 hours, my lord, my passport was returned to me and I was told, you're free to go home. When I asked, my lord, what is my fault? Why have you detained me? Why was I not allowed to board the flight? They said nothing. So, my lord, I, my lord, prevented from boarding the flight. I don't know, my lord, under what instruction, under what, my lord, for what reason. So, my lord, I come, my lord, and I file this writ petition, and that is why, my lord, the writ petition is originally against, my lord, the customs authorities. At that point in time, my lord, I don't even have the lookout notice with me. Now, my lord, thereafter, my lord, the customs comes and come and say, my lord, we had nothing to do with it. We acted on the instructions of the immigration authorities.
You have served also.
So, my lord, now I made the immigration authorities party.
Yes.
Immigration authorities came, my lord, they took time, about three or four times they took, my lord, time to file their affidavit. Ultimately, they came and filed a short affidavit saying that what am I to do? I got instructions from the Punjab National Bank.
You are for the bank?
Yes, Punjab National Bank.
Union of India Immigration, my lord.
Yes.
Yes,
So, my lord, they came and said, immigration, my lord, has, my lord, I'll show you, lordship, my lord, 3-page affidavit. I did nothing. Punjab National Bank issued to me saying,
Bank's intimation to the
bank's intimation, please detain them. Then, my lord, the Punjab National Bank, my lord, I made a party. They appeared. Then, my lord, they took time to file their affidavit on 3 occasions. So, my lord, this has consumed 1 year.
during which, my lord, I have not been able to travel, my lord, from May last year. Now, my lord, every time, my lord, the matter comes up, my lord, there is some reason or other, my lord, to, my lord, derail the matter. That's why, my lord, we mentioned the matter, my lord, upon special mentioning, my lord, 2 or 3 times, my lord, Mr. Chakraborty mentioned the matter, and your lordship was gracious enough, my lord, to entertain this. Now, my lord, I'll tell your lordship, my lord, the bank, my lord, has now filed an affidavit where, my lord, the only point taken by it is you're a defaulter. You're a defaulter, you're a bad man. I have initiated willful default proceedings against you, and I've also sent your case to the CBI. And your matter is also pending before the NCLT. So you should not be allowed to travel.
Why
And,
CBI?
my lord, that they are best, my lord, because I'm a defaulter.
What that CBI?
So, my lord,
I'll
my lord, I'll tell your lordship.
Yes.
My lord, now, my lord, the normal, my lord, modes of recovery, my lord, which are prescribed in the statute, my lord, are being followed, no doubt. But, my lord, the other modes, my lord, of harassing, my lord, and coercing, my lord, are also being resorted to. And now, my lord, there are, my lord, at least 3 judgments of our court, my lord, by three different judges. My lord, your lordship's judgment is there. My lord, then, my lord, Justice Shampar Sarkar's judgment is there, and, my lord, Justice Moushami Bhattacharya's judgment are there. All saying, my lord, that, my lord, basically 2 things. Firstly, my lord, what they do is they come and show you the office memorandum. This is the memorandum under which we can do it. But, my lord, the law, my lord, that your lordships laid down, my lord, in the Visa Steel matter is that, my lord, merely the fact that you have the power is not enough to show that there exists reasons to exercise the power. Now, my lord, absolutely bald, my lord, because you have taken a role, you have not you have defaulted, you have not paid, I have initiated willful default proceedings against you, and that's why you should go. My lord, may I, my lord, therefore, in this matter, my lord, take the extraordinary step, my lord, of my lord, my affidavit on reply, my lord, to the banks, my lord, may I just hand that in? I have, of course, given it to my friend.
I
My lord,
will
may
take
I, my lord, start by,
You
my
got
lord,
a copy of that office memorandum?
Lordship.
Yes, my lord, it's
Let's hear
all
the
there.
matter. Yes.
My lord, may I just start, my lord, by straight away, my lord, inviting your lordship's attention first, my lord, to the judgments, what your lordships have decided, and thereafter take you to the facts. My lord, the first judgment I rely upon, my lord, is your lordship's.
Mr. Shah, before going to the judgments, have you been informed the exact reason why this? Have you got a copy of the lookout circular?
My lord, we have now got the copy of the lookout notice from their affidavit.
Have you got a copy of the bank's intimation also?
That's the my lord, no, my lord, the
I mean, the
lookout notice.
ground on which the intimation was
My lord,
given.
I'll show your lordship what we have. My lord, it doesn't disclose any grounds.
Very good. Then let us proceed with the
Yes,
judgment.
my lord, I'll just, my lord, take, my lord, 5 minutes over the law, my lord, and then take you to the facts. My lord, kindly first take 2021 SCC online, Calcutta 3074. Daro ami dichi. Okay, copy. You want to copy? My lord, kindly take this judgment, my lord, from paragraph 11. The first such argument, the first such judgment was rendered in Mrityunjoy Singh, reported in so-and-so, on the proposition that mere mention of power in the counter affidavit or AO cannot take the place of giving reasons for exercise of such power by issuing the LOC. Learned Counsel next cites Karthik P. Chidambaram versus Bureau of Immigration, reported in so-and-so, in support of the proposition that LOCs are coercive measures to make a person surrender to an investigating agency or a court below, and would necessarily have to contain the reasons for such request, which is, my lord, what your lordships have always laid down. Then, my lord, paragraph 13, my lord, from the last line of this page, recourse could not be taken to the higher remedy of issuance of LOC merely because the word public is involved does not elevate a mere default to an exceptional plane. No case having been made out that the departure stroke travel of the petitioner would adversely impact the share market of the economy of the country as a whole, which destabilizes the entire economy of the country, the LOC is liable to be quashed. For such proposition, Learned Counsel places reliance on the unreported judgment in RV 23 of 2020. Next, relying on another unreported judgment of this court in Mrityunjoy Singh, reported in so-and-so, learned counsel submits that in order to affect the economic interest of the country as well, the case should be of such higher magnitude, which shakes the economic stability or finances of the country, or is of such nature that the banking system of the country is under a threat in the event of the petitioner leaves the country. In Imperial Chemicals, reported in so-and-so, Delhi High Court held that merely to parrot the language of the empowering statute does not comply with the requirement to give reasons, and the cryptic nature thereof cannot be said to be well-founded reasoned decision. It is further submitted that mere fact that the company was in liquidation per se does not create a cause of action under the relevant circulars, and such apprehension is misconceived and does not fall under the exceptional category. So, my lord, the law has been discussed by your lordship elaborately. Next, my lord, kindly take, my lord, paragraph 31. My lord, there were two decisions, paragraphs 26 and 27 also, my lord. May I just quickly show your lordship, which is, my lord, possibly, my lord, cases where, my lord, the impounding of the passport, or, my lord, the restraint on travel was upheld. As regard Hemant Kumar Banka versus UCO Bank, my lord, your lordship has distinguished these judgments. Relied on by the respondent number 2, the petitioner contends that the fact that the said cases were different, since the matter pertained to a defaulter in Singapore who left the country and was also trying to leave India for a job in Tanzania in order to evade the Indian bank, which had international ramification. Distinguishing Om Prakash Bhatt, also relied upon by the respondent number 2, it is argued that the writ petitioner was allowed in the said case, and the petitioner was allowed to travel abroad on condition that the petitioner would disclose his travel details, including date of return, to the CBI. Such order was passed in view of the request for LOC at the instance of CBI and pending proceeding to Kingfisher Airlines, as the petitioner therein was the ex-chairman of State Bank of India, who was required to depose in regard to certain loans distributed to Kingfisher during his tenure as the chairman. My lord, here he was allowed to travel, but, my lord, on certain conditions being imposed. Now, my lord, kindly take paragraph 31. The respondent number 2 next relies on OM. This is, my lord, the office memorandum, my lord, which is the empowering document. Issued by the Government of India, Ministry of Finance, dated October 4, 2018. This is the same OM, my lord, that they have relied upon in their affidavit. Clause 2, which indicates that the chairman of the respondent number 2 bank is the competent authority at whose behest a lookout circular could be issued. The IBA circular dated March 16, 2019 is based upon the OM, as discussed above, enunciating how a public sector bank can make a request for issuing an LOC. It is contended. Then, my lord, paragraph 34. It is submitted that willful default proceedings and proceedings under the relevant provisions of the IBC are different in nature. Willful default proceedings are guided by the master circular dated July 1, 2015, wherein the scope and ambit of the proceeding is different than that under the relevant provisions of the IBC. And it's a very, my lord, elaborate and, my lord, well-reasoned judgment. Kindly now, my lord, come to the concluding paragraphs, my lord, at paragraph 41.
Elaborate narration of the arguments of the parties.
My lord, I have myself appeared in this matter.
Yes, yes. So my learned friend, my lord,
Right.
will know, my lord, that.
Right. So this was their credit, actually. Their arguments have been recorded up to this.
Yes. My lord, kindly have it from paragraph 41. However, it is evident from the factual reconnaissance of the judgments cited on behalf of the respondent, in order to substantiate the allegation of exceptional case having been made out for issuance of the present LOC, that the said reports are besides the point vis-a-vis the instant case and have no direct bearing on the facts of the latter. My lord, here, my lord, there is a case where 351 crores was due.
Yes.
In our case, my lord, it is not, my lord, quite so earth-shattering, my lord. It's, my lord, in the region of, my lord, about 50-60 crores. But that also, my lord, the bank has come to a settlement with me, my lord, for about 23 crores. In any event, my lord, paragraph 47. Undoubtedly, rupees 351 crores is a substantial amount of money. But the lookout notice was silent as to why the extraordinary circumstances were alleged by the respondent number 2 bank in its request for the LOC. In fact, both the LOC as well as the request by the bank for issuance of such LOC were cryptic with regard to the ground of issuance. Then, my lord, in paragraph 50, there was an amendment to the office memorandum. Your lordship has referred
Detrimental to sovereignty, security, etc.
Yes. In exceptional cases, LOCs can be issued even in such cases and would not be covered by the guidelines above, whereby departure of a person from India may be declined at the request of the authorities mentioned in clause B above referred OM. If it
Their
appears
base grounds are, Mr. Shah, economic, detrimental to economic interest of India, and also ought not to be departure, ought not to be permitted in the larger public interest.
Larger public interest, my lord, threat to sovereignty.
Threat to sovereignty, and those probably they won't argue here. But
They
primarily economic interest of India. Otherwise, threat to sovereignty, bank, if the bank starts deciding that, then it's very difficult.
I'll show you, lordship, what that thing says.
Economic interests of India, larger public interests may come in, subject to what Ms. Raichuri says.
Now, my lord, kindly take, my lord, paragraph 51 and 52. None of the above criteria are satisfied in the present case. The mere quantum of the alleged default cannot be a basis for the extreme measure of restricting the personal liberty of petitioners to travel inside or outside India. In the absence of any such ground, the LOC was ex facie vitiated. In the event the authorities seek to resort to the quantum of alleged default for restricting citizens' departure outside the country, it is obvious that the quantum is relative and the amount of rupees 350 crores can be exorbitant or meager, depending merely on the whims of the authorities or the perspective of the judge. As such, in the absence of any stipulation in that regard in the relevant office memorandum, no cutoff line can be drawn between an amount which is detrimental to the sovereignty or security or integrity of India or to economic interests of India and one which is not. Then, my lord, kindly have 55. My lord, I'm not reading the other paragraphs.
Objective parameters have probably been highlighted here.
Yes.
There has to be object somewhere. It's
My lord, kindly, my lord, have 55. Rather, in the present case, the respondent number 2 bank has abused its authority to request for opening a lookout circular at the behest of the chairman, managing director, chief executive in the capacity of a public sector bank, thereby substituting a regular proceeding for recovery of debt in the process. The issuance of the LOC cannot be an alternative for initiating recovery proceedings against the borrower itself, let alone director of the borrower entity. Now, my lord, this judgment of your lordship is, my lord, thereafter, my lord, the copy the. My lord, surprisingly, my lord, Justice Shampa Sharka's judgment, my lord, that doesn't appear to have been reported. My lord, I'll hand up the internet copy.
Please give a copy.
এটা যেটা দিয়েছো এটা mark না তো? Sure তো? This is also, my lord, your lordship will find.
But the same person was again detained.
I think at the.
I hope you are not Bishamar Charan. You are not Bishamar Charan.
No, my lord,
Third time is very risky.
I am Mittal.
Oh, worse than that.
No, not the Mittal who's sitting.
That's why worse than that. You're much more well off.
No, I'm not the Mittal, my lord, who is now presently having, my lord, the state dinner with Joe Biden. But, my lord,
many persons are having state dinners. Anyway,
my lord, this is also, my lord, a very elaborate judgment. So, my lord, I will not, my lord.
Since it is not my judgment, Mr. Shah, you need not so
Yes,
elaborate.
my lord, I thought so as well.
Yes.
My lord, I think I've
If it was my judgment, definitely it
Yes,
would
my lord,
play in my mind that my judgment is being so
these are
important.
fundamentals, my lord.
The
which
fundamentals, yes. So
my lord, may I
bypass the
just-
fundamentals, Mr. Shah. Just point out the relevant
Yes, my
factors.
lord, I'll just, my lord, take your lordship straight away
And particularly after being reminded from the previous judgment that the majority of that was arguments of parties. After they reminded that, Mr. Shah, it's all the more. I mean,
No,
yes.
my lord, in this judgment, my lord, I want first to invite your lordship's attention to the fact
Yes.
that, my lord, most, my lord, of the other decisions have been considered. If your lordship kindly takes it from page 28 onwards.
Yes, it is. It does.
My lord, E.V. Perumal, Sami Reddy, my lord, is considered. Then, my lord, Showman Sharkar, State of Tripura is considered. Then, my lord, paragraph 54, Karti P. Chidambaran, which, my lord, also your lordship has considered, is been considered. Rahul Surana, serious fraud, that is considered. Vikas Chaudhary is considered. Brij Mohan Patua is considered. Rana Ayub. So, my lord, all
Rana Ayub is this the lady who wrote Gujarat Files? I'll have to check up. Anyway.
Now, my lord, kindly have it from page 32, paragraph 59.
59 years.
These are the findings, my lord, of the learned judge. Starts from here. In my opinion, personal liberty and fundamental right of movement guaranteed by the Constitution cannot be curtailed at the behest of Bank of Baroda when the conditions precedent for making such a request for opening an LOC did not exist in this case. The affidavit in opposition does not disclose that the managing director executive officer had applied his mind or received information or input from any investigating or intelligence agency to come to the conclusion that the petitioner was trying to flee from India in order to evade the legal consequences of such default. It is also a matter of record that the proceedings with regard to willful default is still pending. And the bank has not disclosed any material to show that any other proceeding under any applicable law, be it civil or criminal, has been initiated. Non-payment of the loan and the dues of the bank cannot be equated to an act of destabilizing or affecting the economic interest of the country. The freedom of movement of a citizen is a valuable right and cannot be infringed except by imposing reasonable restrictions. The court does not find any reasonableness in the actions of BOB. The lead bank PNB failed in its attempt to restrict the movement of the petitioner. No subsequent development has taken place which would justify a further request by the BOB on the self-same cause of action. This, my lord, is the reason. The first judgment, my lord, that your lordship passed, my lord, was at the instance of PNB.
Yes.
And now, my lord, at the instance of BOB. Now, my lord, kindly, my lord, now have, my lord, paragraph 63 at page 34.
Yes.
A bold assertion that the petitioner's departure would be detrimental to the economic interest of the country and the LOC must be used in larger public interest.
These are the two grounds used by the banks generally. Obviously.
Yes, my lord, I'll show you, lordship. My lord, these are must be issued in larger public interest, cannot be due satisfaction of the existing preconditions required to be fulfilled before the originator can make such a request. The existence of such preconditions and the manner in which the action of the petitioner fell within the exceptions or had affected the country's economic interests had to be demonstrated from the records. The apprehension should be well-founded, backed by reasons, and also supported by evidence. The decision of the Karnataka High Court in Dr. Bhavaguthu Raghuram Shetty does not apply in the facts of the case. With due respect, the court does not agree with the conclusions arrived at in the said judgment, especially with regard to the comparison between the quantum of loan and the annual budget of the state. Whether the outstanding loan with interest would be more than the budgetary allocation of a particular state or not, in my opinion, is not one of the parameters to be considered. That, my lord, could have, my lord, more than the budgetary allocation of the state may have come, my lord, within the exceptional circumstances. The bank acted in arbitrary exercise of power vested in it by making a request for opening LOC, which was an attempt to curtail the personal liberty and fundamental right of movement of a citizen by the Constitution of India. The request of BOB for issuance of LOC dated so and so, if any, set aside, quashed, bank is liberty. And, my lord, the last, my lord, judgment on which I wish to rely upon, my lord, refers to both these judgments, my lord, earlier judgments. 2023 SCC Online, Calcutta 1442. My lord, kindly have it from paragraph 12 onwards. Lookout circulars, which have the effect of restricting a person's free movement and the right to travel, should only be issued in exceptional circumstances. Lookout circulars cannot be issued at random and at the slightest provocation, particularly at the instance of a bank who seeks restrictions on travel as a buffer to payments outstanding to the bank. The only acceptable logic, albeit with regard to effort, is that the person may flee the country and not return to repay his or her outstanding loan. This, however, cannot be the rule across the board, and the borrower's credentials and circumstances for making payment must be taken into account. There is something draconian and uncivilized in a person being deboarded from an aircraft, which is what happened in my case. I was sitting in the aircraft. Deboarded from an aircraft without being informed of the reason for such. In most cases, the person concerned is simply handed a piece of paper and told at the last moment to deplane without being made aware of the reason. My lord, exactly my case. This is against the principles of natural justice and fair play in action, where the fundamental right to travel and the right to life is inexorably compromised and with impunity. The extreme repercussions of issuing a lookout circular must hence be regulated to give it form and certainty and not be made a norm for recovery of outstanding payments to the banks. Isolated and few and far between cases of persons fleeing the country cannot become the uniform rationale for issuing of lookout circulars left, right, and center. Then, my lord, paragraph 15, my lord, Vishwambar Saran's cases, my lord, referred to. Although the quantum of due to the respondent number 8 is disputed, Vishwambar Saran, Bureau of Investigation, so and so, shows that the quantum alone cannot be the determining factor for preventing a person from leaving the country. Then, my lord, paragraph 17, about 5 lines from the bottom, where the last version is that the LOCs could be issued in exceptional cases not covered by the guidelines in the OMs and at the request of authorities impugned in the OMs, where the departure of the person concerned would be detrimental to the sovereignty, security, and integrity of India, or is detrimental to the bilateral relations with any country, or to the strategic and economic interest of or that person, may potentially indulge in any act of terrorism or offense against the state, if such person is allowed to leave, and where travel ought not be permitted in the larger public interest at any given point of time. The expressions used are from the OM dated 22nd February 2021, which has been extracted in one of the decisions referred to above. Then, my lord, 19. The ground used against the petitioner is evidently economic interest of India. There is no evidence that the petitioners leaving the country for a specific period of time would affect the economic interests of India. The petitioners have not been declared fraudsters or money launderers or even economic offenders. Apart from the reach of the lookout circulars to cause immediate and irrevocable violation of a person's fundamental right of movement, lookout circulars have inexplicably long shelf life. Subparagraph 3 of the OM dated 22nd February 2021 mandates that a lookout LOC shall remain in force until and unless a deletion request is received by the Bureau of Immigration from the originator, and no LOC shall be deleted automatically. Although these clauses cast an obligation on the originating agency to review the LOC on a quarterly/annual basis and submit proposals for deletion of the same, this is sadly found to be absent in most cases. Once a lookout circular is issued, it remains alive and kicking for almost all times to come. This spells dangerous repercussions on the person's right to freely move across and beyond the country and remain mobile. The banks have been given untrammeled powers to issue, use, exploit, lock-in power of a lookout circular without sufficient recourse being provided in law to the person at the receiving end of it. The expressions detrimental to economic interest of India in the concerned OM is sufficient to sharpen the talons of a vindictive bank to clip the wings of a vulnerable prey in the metaphoric sense. The felicity of the language, my lord, makes it worth the reading.
Yes, yes, absolutely.
The writ court hence can and should step in to check such unregulated abuse of power by banks where the facts demand relief. In view of the above reasons, so and so, my lord, cannot be continued. Now, my lord, these are, my lord, the three judgments, my lord, which I basically rely upon.
Yes.
Having, my lord, taken your lordship, my lord, to these, my lord, may I now invite your lordship's attention straight away, my lord, first to just, my lord, for a moment to the writ petition, and then I take.
Please take your seats. Yes. Writ petition. Yes, Mr. Shah.
Yes, my lord, in the writ petition, my lord, your lordship will see. My lord, I first want to show your lordship the reliefs that I had claimed. My lord, kindly take it from my lord, prayer C onwards. Now, my lord, at that point in time, I did not have anything. My lord, therefore, my writ petition does not have any reference to Punjab National Bank. Does not even, my lord, refer to, my lord, the immigration authorities. I made, my lord, my respondent number 4 is the customs. And my specific pleading, my lord, so that, my lord, my learned friend, my lord, cannot get, my lord, hyper-technical and say that the necessary prayer is not there. My lord, kindly see, my lord, page 4, paragraph C. This is what happened. I had not a single document. Accordingly, the petitioner with a view, page 4, my lord, paragraph C. Accordingly, the petitioner with a view to travel to Dhaka on 16th May 2022 went to the airport, completed all necessary formalities such as immigration clearance, and thereafter proceeded to board the aircraft by which petitioner was to travel to Dhaka from Kolkata. A copy of the boarding pass, my lord, I have annexed. However, after boarding the aircraft, 5 men descended upon the airplane and approached the petitioner. Out of the 5 men, 3 were in the uniform of the customs department, while the remaining 2 purported officials were in plain clothes. These gentlemen introduced themselves as officers of the customs department, demanded to see the passport of the petitioner. Upon the passport being handed over, the petitioner was requested to deboard the aircraft, accompany the said officials to their office. With a view to avoid any confrontation, petitioner complied with such demands, accompanied the customs officers situated at the Netaji Subhash Chandra Bose International Airport. Petitioner kept on inquiring as to why he has been singled out and why, well, while should be read as why, why he has been deboarded from the aircraft. The petitioner was informed that they have only been instructed to prevent the petitioner from traveling. Thereafter, petitioner inquired whether there was any lookout circular issued against him, answer to which was given in the negative. Thus, the petitioner constantly requested the officials to allow him to travel to Dhaka for business transaction for his company. However, such requests fell on deaf ears, and the petitioner was confined to the office of the customs authorities of the Kolkata International Airport. As a result of such confinement, the petitioner missed the flight to Dhaka. However, after keeping the petitioner waiting for 2 to 3 hours at the said customs office at the airport, the officials handed the passport of the petitioner back to him and allowed him to leave the airport with the caveat that he will not be allowed to travel. It is appropriate to mention that no order of any no order or any such document was ever shown or produced before the petitioner to indicate that why it should be, my lord, he is being prevented from traveling by some procedure established by law. So, my lord, I have made an elaborate pleading that, my lord, at the point in time, my lord, when I, my lord, filed the writ petition, my lord, I had not a single scrap of paper. Now, my lord, kindly permit me, my lord, to once, my lord, invite your lordship's attention to my passport. Because, my lord, the apprehension is that if I once am allowed to travel out of the country, I will never come back. Now, my lord, kindly see my passport, which, my lord, I have annexed from page 16 onwards. And kindly see, my lord, I have been traveling all along, all over the world. And never, my lord, tried to, my lord, run away, flee. So, my lord, if your lordship, my lord, kindly sees, my lord, my passport, my lord, starting from page 16 onwards, my lord, it's full of stamps. And, my lord, permit me to
have you traveled abroad after the loan, after this transaction alleged?
Yes.
After that also?
No, after I was, my lord,
After the
for-
transaction in question, I mean, for
yes,
which
my
you
lord, the
have been-
transactions in question, my lord, are 10 years old.
Very well.
My lord, kindly now permit me to, my lord, show to your lordship, my lord, just one more document. My lord, my boarding pass, which your lordship will find, my lord, at page 27. To show your lordship, my lord, that I was allowed to board the flight and I had taken off from the flight. So I was given my boarding pass. After being given my boarding pass, my lord, I was, my lord, made to deplane. And my lord, the boarding pass, my lord, your lordship will see, was issued and then, my lord, cancelled with, my lord, the CWOPs. It's something without prejudice. Cancelled without prejudice. So, my lord, this is, my lord, the gamut of the facts, my lord, when I came, my lord, to the writ court. Now, my lord, kindly take the, my lord, affidavit of the Punjab National Bank. Or, my lord, may I just, my lord, first show your lordship, my lord, the very brief affidavit filed, my lord, by the Immigration Authority.
Respondent number 5 is the Immigration Authority.
Yes, my lord. No, আমারটা চাই আমারটা চাই
Originating agency all through,
yes,
which is the bank.
Yes.
Para 9 is probably interesting.
Yes. My lord, kindly take, my lord, the affidavit of Mr. Prashanto Kormokar.
Yes, Mr. Shah, actually I've seen it. You may read the paragraph 9 only.
Very well. Very well.
That is the most
I say that
interesting
the
part.
Bureau of Immigration acted as per the instructions laid down in the lookout circular. Lookout circular is the lookout circular is a secret document. No instructions exist on the lookout circular. Guidelines regarding serving of lookout circular issuance to the issuance to the lookout circular subject. Hence, the matter is classified nature. No communication is made with regard to lookout circular subject from the Bureau of Investigation.
Should have been paragraph 007.
The only thing,
Anyway, so immigration is putting it on the original.
on the original.
Naturally, yes. They will say so.
Yes, my lord,
Obviously.
and which is, my lord, the fact that they have, my lord, merely followed the instructions.
Yes,
my lord, of the
that
bank.
is the present office memorandum is also that. I mean, they have to act on that.
Yes.
Probably they
Now-
don't have much discussion.
Yes. Now, my lord, kindly have, my lord, the bank's affidavit. You know, কাগজ গুলো গেল কই? My lord, this is affirmed by
The
Anil
thickest
Kumar.
one. The
An-
thickest one.
Yes. Anil Kumar Mondal.
Anil Kumar Mondal, yes.
Yes. Now, my lord, I'll just, my lord, very quickly run your lordship through, my lord. Page 4, Roman 3. The said company, Brahmalloys, my lord, the company in question is Brahmalloys, through its directors, guarantors, Bajranglal Mittal, Manish Mittal, and Sonal Mittal, obtained credit facilities from the Punjab National Bank. Then, my lord, page 5. My lord, these are my group companies. I don't know, my lord, what my group companies have to do with this matter, but anyway, my lord, they've given the group companies. Then, my lord, Roman 5. My lord, total loan given is 87.07 crores. 87.07 crores. My lord, this is, my lord, comprises of Punjab National Bank and Karnataka Bank. So now 87 crores is not a loan, my lord. Punjab National Bank not a loan. Punjab National Bank is, my lord, only 68.42% of this 87 crores. Then, my lord, then, my lord, kindly come to, my lord, Roman 8.
Yes.
It is also submitted that work of forensic audit was assigned to BKS and company for the review period 1st April 2017 and 16 September 2019. My lord, I'll show to your lordship that, my lord, they have, my lord, the only justification saying there was a forensic audit. Forensic auditor came to some conclusion, and on that basis, we are issuing that notice. Forensic audit, my lord, No notice given to me. And my lord, I'll show your lordship, my lord, the forensic audit.
By definition, it's sick of foreign. So naturally, LOC can be issued at on that premises. That can be. That's a
My
good
lord,
logic also.
it is, my lord, by the auditor's own admission,
Yes.
a document, my lord, which should not be relied upon. He keeps on saying, my lord, and not in one place, in several places, that
This
please don't-
matter in the report.
Yes.
So this is
The
not
caveats. Yes,
Oh,
the
usual.
report is full of caveats. Say, I didn't have any documents, so what I'm doing is all on the basis of surmise, guesswork. So please don't use it anywhere. We take no responsibility for it. So, my lord, I'll take your lordship to those portions. Then, my lord, my lord, kindly, my lord, have, my lord, page 8, where they say, my lord, that they have annexing, my lord, the forensic audit report as R2. Then, my lord, Roman 9 at page 8. Further, on 18th March 2021, the Punjab National Bank, by way of written complaint, requested the head of the zone so-and-so CBI for registering an FIR and further investigating the above company, and directors for having committed offences of fraud by siphoning of funds. So everything under the sun. I'll show your lordship, my lord, with such fraudsters, they've entered into, my lord, now with compromise and things have taken a different
CBI will should find a public interest litigation, Mr. Shah. CBI will be filing that soon.
Yes, my lord, I sometimes wonder how they can, my lord,
How they could manage.
the,
Yes,
the
exactly.
whole country's workload.
Very difficult
How
for
is it?
them actually.
Then, my lord, page 9, paragraph 11.
Yes.
Last 3 lines. 25th April 2022, company has been identified as willful defaulter. Order passed by identification committee.
Not yet review committee.
And, my lord, I had, my lord, in one matter had the occasion to argue before your lordship that the review committee is not the appellate authority, and your lordship has passed, my lord, an order, my lord, agreeing, my lord, to this. It's not the appellate authority of the identification committee. It's a 2-part process. So you've only been declared as half a willful defaulter. So, my lord, it really doesn't take effect. So, my lord, in all these cases, my lord, where they, my lord, go to SABYASACHI and upload it, my lord, before, my lord, review committee, my lord, decides, is perhaps, my lord, not the. Then, my lord, at page 10, Roman 12, it is also submitted that on behalf of the respondent bank, the lookout circular being government office memorandum issued by the so-and-so, dated 27th October 2010. My lord, this is, my lord, the memorandum which was there. This is, my lord, the first memorandum. First memorandum, my lord, if your lordship sees the last 3 lines at page 10. These authorities include Ministry of External Affairs, Customs, Income Tax, Directorate of Revenue Intelligence, Central Bureau of Investigation, Interpol, Regional Passport Officers, Police Authorities.
Mr. Shah, probably authority is not a point in issue.
My lord, initially, the memorandum did not contain the banks.
No, now.
Then, my lord, the next, my lord, the circular, which, my lord, a memorandum, which is, my lord, page 11, Roman 13. This is, my lord, where, my lord, the banks are brought in. PSUs, public sector banks are brought in. And this is, my lord, the my lord, document that they rely upon. So, my lord, the first document that they produce in support of their case is, my lord, this, my lord, circular of 4th October 2018. Then, my lord, they rely upon, my lord, the Indian Bank Association, my lord, has, my lord, then followed it up with great gusto and, my lord, enthusiasm, because, my lord, is a powerful tool in their hands. Then, my lord, Roman 16 at page 12. The respondents further submit that in view of the above, I don't know in view of what above, what is the exceptional circumstances, threat to sovereignty? In view of the above, Punjab National Bank has requested Bureau of Immigration for issuance of lookout notice against the said Bajranglal Mittal, so-and-so, immigration on 21st May 2021. This will appear from the letter of 14 June. Now, 21st May 2021, they have not annexed. This is, my lord, the document which will contain the reasons that for A, B, C, D, E, F, G, H reasons, please issue the circular, lookout circular. This letter, my lord, 21st May 2021, my lord, and I'll take correction from my learned friend, my lord. Because, my lord, very often, my lord, yes, kindly see your answering respondent craves leave to produce the letter of 21st May. So, my lord, they have not given the documents which, my lord, should be containing the reasons. They have not even given the document. So, based on this 21st May 2021, my lord, 14th June is, my lord, issued. My lord, kindly permit me straight away to take your lordship to the 14th June circular.
They say the circular was issued by the Bureau of Immigration on May.
On the basis
on the
on
basis,
the
is not
basis of, my lord, their request contained in the letter of 21st May 2021.
At page 13, they say the fourth line, the said circular was issued by the Bureau of Immigration on the date of May 21. If they mean on the basis of that,
On the basis, my lord, it should be. My lord, I'll show you the document will speak for itself.
Very well, very well.
The document, my lord, will speak for itself.
Yes, yes.
Kindly give me one moment, my lord, please. एक कोई गलो बोलो तो मुझे पता ना, as usual. Kindly grant me one moment.
Immigration has not annexed because it's a secret document.
Yes,
It's classified.
it's a secret document. अरे छोटे गलो बोलो. Lordship, give me one moment, my lord.
Yes.
अरे lookout notice तो पता है गलो. 16th. আমি একটু দেখেছি, আমি একটু দেখলাম তো, মার্ক করতে ফ্ল্যাগ করতে ভুলে গেছি, আর পাচ্ছি না. 115 115 115. Yes, my lord. Kindly have page, my lord, 115. This is, my lord, the letter. This is the letter on which, my lord, I have been restrained. And this letter refers to, my lord, 21st May 2021 letter. This has reference to your recommendation for issuance of LOC in the above account. In this connection, we have to inform you that we have requested Bureau of Immigration via letter dated 21st May 2021 for issuing LOCs in the name of following promoter, director, guarantor have been issued on so and so white BOL letter of so and so. As per, yes, my lord, I stand corrected, my lord. As per MHA, so and so 27th October, LOCs are valid for a period of 1 year from the date of issuance. Name of subject automatically removed from LOC thereafter. I'm sorry, my lord. I'm sorry. My lord, your lordship will see, my lord, this is, my lord, an internal correspondence of the bank. This is the only thing that they have annexed.
So if that be so, then Mr. Shah, this writ petition has become infructuous. They cannot.
No, 1 year, but my lord,
But
it's
they
still
detained
there.
you after that.
They're continuing. My name has not been removed.
Must have been removed.
My name has not been removed. I continue to be there. And my lord, this is, my lord, one officer of the bank telling the other officer of the bank.
Yes.
So, my lord, nothing is before your lordship. My lord, neither the 21st May order, my lord,
Other
neither
Justice
their
Koshi
request.
Bhattacharya's order says that it has a long shelf life. I mean, indefinite shelf life, something like that.
Yes, my lord, they don't renew it.
So there's, yes.
My lord, your lordship will kindly see. This is, my lord, we have to inform you, we have requested Bureau of Immigration by letter dated so and so for issuing. That's it. The letter itself is not produced. They crave leave to So, my lord, the reasons, my lord, on the basis of which they've done it, my lord, they have not produced it in their affidavit. It's not produced in their affidavit. And immigration, my lord, office says, my lord, that they can't produce the lookout notice.
But we have, my lord, mentioned the details in the paragraph 3, my lord.
Yes, yes, that they have done. On that basis, my lord, they have. Paragraph 3, my lord, they have given the details, my lord, of the fact, my lord, why they've restricted me. So, my lord, all that your lordship has, my lord, from the Punjab National Bank, my lord, is this documented 115, nothing else. And, my lord, kindly scan this document, my lord, to see whether, my lord, it contains one word about, my lord, if I leave the country, I will never come back.
They crave leave to produce that document. Let us see whether they produce. May
Let them
21st.
produce it, my lord. They crave leave to produce it, my lord. They should
Their opposition they
inform
have.
us. So, my lord, but the document that they have produced, my lord, kindly see, my lord, threat to sovereignty, integrity, public interest, my lord, economic interest, nothing. There's not one word about anything. My lord, these are my respects.
Yes. Thank Bank.
Lordship, before I start on, I'll still pray for time because Mr. Shomra Chen is engaged in the matter. He was appearing, Your Lordship, since we have been served with the copy of the mentioning slip just yesterday that the matter will
Just
come up.
Shen comes, give me the letter. Dated May 21st of May. You have
When-
craved leave in your operation.
Lordship, I will try to bring it on the next day of hearing. That
The
is on
time of
Monday.
hearing you have to produce. You
At the
have craved
time of hearing, I'm just praying
This
for
is the
Monday.
hearing. I'm refusing that.
Monday, Your Lordship.
No.
This is the time that I'm praying for. Because we were not informed priorly, because the matter was mentioned on 16th, Your Lordship. We have just been informed just yesterday, Your Lordship. This is the only thing that I'm praying for. Just one day. They have filed this application on 22nd of March, Your Lordship. They have waited till today.
When was the copy given to you?
Yesterday at 2:37 p.m. Yes, Your Lordship, the letter itself
Not
contains
the
this.
letter, the copy of a copy of the writ petition. You have used your affidavit.
Lordship, affidavit was served, Lordship.
After 4 attempts.
Today the matter will come, Your Lordship.
It was sufficient.
Lordship, I bow down before Your Lordship. I'm just praying for a day's time, Your Lordship. Monday, Your Lordship may fix the matter at any time, Your Lordship. Your Lordship, if Mr. Shane is not available, I'll myself argue the matter, Your Lordship.
But you have to bring a copy of that letter.
Lordship, anyhow, I'll try to bring it. And this is the letter, Your Lordship, that the Bureau of Immigration has sent, not our letter. I'll
You have
refer
not
to.
annexed your letter, that's why.
I have not annexed our letter,
Gravely.
Lordship. I have gravely for producing the letter of the Bureau of Immigration that was sent to us. However, Your Lordship, I will try to bring.
not
Yes,
that.
Your Lordship, 21/5/2021. Your Lordship, if may kindly come to page number 115.
So, my lord, their reasons are not there at all. If, my lord, they say that, my lord, the 21st May, my lord, is the letter, my lord, given to them by the Bureau of Immigration, then, my lord, their reasons are not there at all. They don't even make a pleading that, my lord, they have, my lord.
No,
given any reason.
here you are saying that you crave leave to produce a copy of the letter dated May 21, 2021. And you have annexed a letter dated June 14th. In that June 14th letter which you have annexed, you have stated, it is stated, in this connection, we have to inform you that we have requested Bureau of Immigration, our letter, the bank's letter, dated May 21, 2021, for issuing LOC. Therefore, you have referred to that letter in this.
Lordship, I stand corrected.
So that your letter is also of the same
I
day.
stand corrected. Yeah,
So you have to produce that letter. That is the
Lordship,
premise
next
of
time I'll try to produce that on the next day of hearing. That is by Monday. Lordship, it's the only thing that I'm praying for.
I'll grant that.
Very well.
At order record. The matter is heard in part. Now, heard learned senior counsel appearing for the petitioner at length. First up, next para. It transpires from the arguments that the bank's letter, comma, purportedly dated May 21, 2021, comma, which was the premise of the issuance of the impugned LOC, comma, has not been annexed to any of the pleadings. First up, next para. Since the bank has craved leave to produce the said document at the time of hearing, comma, learned counsel for the respondent bank shall produce a copy of the said document. Please hold extra copies also to give to them so that in said document on the next date of hearing, first up, on the prayer of learned counsel for the bank, The matter is adjourned till June 26, 2023,
Lordship.
when it will be listed fairly at the top of the list.
I'm grateful to your lordship.
Thank you.
Lordship, and it is my undertaking before the court. If Mr. Shin does not come, I'll argue
That
the
is
matter.
sufficient, Lordship. They need not undertake before the court. You submit from the bar, that is sufficient.
Lordship, I'm so grateful to your lordship.
Yes.
When we were at the bar, I remember I kept telling Mr. Pratap Chatterjee that you have become Pratap Chatterjee because everybody briefed you because you were never ready. So we briefed you so that we would get a chance to argue. We would come and say that to court.
Exactly.
I'm grateful to your lordship.
No, she can apprehend probably the outcome. That's why she's insisting that we say.
No,
She's
because-
sufficiently competent to argue the matter.
Of course, madam.
But she's asking for time because she's rightly apprehending
madam.
probably the
Of course,
outcome.
of
Means a lot, your lordship.
Of
Deeply
course,
grateful.
of course.
Grateful to your
Thank
lordship.
এবার উঠে যাচ্ছে হ্যাঁ না ডাকতে হবে আজকে ডাকতে হবে আজকে উঠে যাবো একটু
Original side matters. Court application item number 1, High Speed Logistic Private Limited and another versus Food Corporation of India.
You're for the petitioner?
Your Lordship, I'm led by Mr. Dotto. Till he
Mr.
comes-
Kishore Dattu?
Kishore Dotto. I'll
Not today then. Or you want to start the matter? Start the matter. I have no issue. You can start the matter. Start the matter. You have served properly on the respondents. Very good. Yes, what is the matter?
Your Lordship, the petition arises out of a show cause and a termination order whereby a contract has been terminated and I have been debarred from participating in any tender for a period of 3 years.
You were heard before the blacklisting?
Your Lordship, not a
Opportunity
personal
was-
hearing, a show cause was given. I have given a reply and then the blacklisting order was passed. But Your Lordship, I'll come to the notice.
What's your main point, your best point?
Your Lordship, the first
indicate that. I'm not cutting you down.
No.
What is your best point? Just indicate to me.
Because Your Lordship, the blacklisting arose out of a conduct which they say is that Your Lordship, I was the L1 bidder. They accept my bid and they ask me that you deposit the security deposit and the bank guarantee within a certain time.
Right.
30th September 2022 was the date by which I was supposed to give the security deposit. I approached the bank. I'll come to the language of the tender as to I was required to submit the security deposit. Your Lordship, I was required to submit the security deposit by that date. I approached the bank. I placed the check and the requisite form. But by some reason, the amount is not remitted. If Your Lordship will kindly see the tender, or Your Lordship may hear Mr. Dotto on that.
Yes, sir.
But I think that a brief background of the case has been given to your
He
lordship.
just started, but he was placing very well, but he has just started. So you can place your case.
Very well. My lord, I am a successful bidder. My lord, letter of acceptance has been issued in my favor. My lord, my obligation is to pay transfer electronically 5% of the contract value. First tranche, my lord, by way of electronic transfer. The second is by way of a bank guarantee. Now, insofar as the second part is concerned, if there is a delay, then, my lord, there is a question of penalty. And, my lord, finally, my lord, there is another clause which says that if I do not comply with this, then there is a question of termination and debarment. This is what has happened over here. Now, my case is that there was no delay on my part in transferring the first part. There is no dispute in regard to the second part, that is the bank guarantee part. There is a dispute in regard to the first part. My lord, the letter of acceptance, my lord, was issued on 12th of September 2022 at page 41, which states that I have to transfer this money, the first part, by 30th of September 2022, which is at page 95. Kindly note down the page number. Nothing much is required.
42 and 95. Page 42, the first one.
Yes, page 42. I'm sorry, Milord, it's not, letter of acceptance is at page 95.
Oh, 94. Right.
Now, please take, Milord, page 95, please take the second paragraph.
Yes.
You are therefore requested to furnish the security deposit for due performance of your obligation under the contract within 15 days, 15 working days, that is, on or before 30th of September 2022. Now, what I do is, please have a look to, Milord, page 99.
Yes.
Where I sent an advice to the bank on 30th of September 2022, which your lordship would find, Milord, in the box. Please take the next page, where this is, Milord, the check.
Right.
Addressed to yourself, RTGS, etc. This is the figure. Now, Milord, from 1st of October to 6th of October, Milord, was Puja holidays. Therefore, Milord, the bank was not functioning. Milord, on 7th October, the bank processed it, but did not remit the amount in the account of the Steel Authority of India. I'm sorry, FCI. Milord, I write a letter to the bank when I come to know on 11th, that is at page 101. Please take the last two lines. I'm reading a part of the sentence as to why the transfer of the above said amount was declined and also for the delay in intimation of the same. But I seek the reason.
But you had to pay by 30th.
By 30th. So the transfer was to take place by 30th because these are automatic, as your lordship knows.
Yes.
Now, Mullah, the bank writes to me at page 102. The ground is, as per your letter dated so-and-so, we would like to inform you that due to multiple overriding in the check against which the RTGS was to be done, and for that reason, the remittance was declined. Also, due to prolonged holidays on account of Durga Puja festival on intermediate working days thereafter has resulted a bit delay in intimation. But what I do is, this is communicated to me on 11th of October. On 12th of October, Milord, I pay this amount. That your lordship would find, Milord, on at page 103. Page 103, 104, and 105, Milord, these are the three documents from which your lordship can gather that, Milord, this amount has been remitted by me. This is so far as the first part is concerned. Now, so far as the second part is concerned, that is submission of bank guarantee. Milord, there was a delay. Milord, I have paid the bank guarantee with the penalty as per the clause.
But then you committed a delay in the first part also.
First part also, there is a delay, no doubt about that.
But the reasons you are saying.
The reasons I am saying, they have accepted it. Milord, I'll be Milord, emphasizing more on the acceptance part in my.
Yes, definitely.
Yes. Then, Milord, the bank guarantee part, Milord, I have complied with. That is page 109 and 113. Milord, these have all happened by 16th of November 2022. Whatever, Milord, I have described so far. Milord, the next obligation of the authorities was to issue an appointment letter to me. Only on the issuance of the appointment letter, Milord, I can render my services. Milord, they were not issuing the appointment letter. Therefore, Milord, I requested for an appointment letter after about 5 months on 18th of April 2023, which is at page 117. Now, Milord, the bank, FCI springs into action, Milord, after I ask for the appointment letter after 5 months. Please take the second paragraph at page 117.
Yes.
Hence, we earnestly request you to issue the appointment letter for the said contract at the earliest so that we can commence the work of transportation of food grains and allied materials within campus of such and such. But FCI writes to me saying that the matter is under review. Next page, 118. This is 2nd of May. Now, my lord, on 16th of May, my lord, the show cause notice comes, which is page 119. Please take note the third paragraph at page 119. However, in the case of the instant tender, Messrs. High Speed Logistics Private Limited had failed to deposit the security deposit amount within the stipulated time, that is 30th of September 2022. Further, as per clause 7, where I'll read that clause separately, this is quoted. Please take the next page. Thus, the act of Messrs. High Speed is in violation of the above mentioned clause of MTF. Therefore, an explanation is hereby called from Messrs. High Speed so as to why necessary action should not be initiated against so and so for the above mentioned violation. But only I'm laying emphasis as to what I have been asked to do. Explain why necessary action will not be taken. But I give my reply at page 121 in details. The relevant part would be page 122, the last paragraph.
Yes.
Page 123, second and third paragraph, where I describe the entire incident and say that there was no willful default on my part and there can be no fault attributable to me. And where I seek a personal hearing, at page 124. And now finally, my lord, the impugned order of termination and banning at page 125. Where the third paragraph in the form of recital, second last line. Second last line, where in the third one, however, the party has failed to furnish the security deposit within prescribed time. Whereas a notice dated 16/5/2023 was served to Messrs. High Speed seeking explanation for his failure to deposit the security deposit within the prescribed time as per MTF clause 7.4. Vide reply dated 29/5/2023, Messrs. High Speed informed that they had deposited the security deposit within the stipulated time period, but unfortunately the same was not credited to the FCI account due to the technical issue of the bank for overwriting the check as submitted to the bank on 30th of September. So these are all admitted by them. From my side, whatever was required to be done, I have done by 30th. That on examination of the reply given by High Speed, it is noticed that the reasons are not convincing and not supported with any MTF clause. The contractor in the tender submission undertaking furnished by him had undertaken that I be hereby unconditionally accept the tender conditions for the above mentioned tender documents in its entirety. As per MTF clause 9B and 7II under the security deposit, there is no relaxation in respect of depositing of this security deposit after 15 working days. The party cannot resile from completing the financial obligations for joining of work based on his claims made as he has accepted the terms and conditions that MTF clause 9F and 7.4 under security deposit is stipulated as under. They quote it. Please turn the page. Then the last paragraph, that even when Messrs. High Speed read the terms and conditions of MTF and also undertaken to abide by them, Messrs. High Speed Logistics failed to furnish security deposit within the prescribed time period, which is in clear violation of so-and-so clause. Hence, the contract awarded to Messrs. So-and-so is hereby terminated. So-and-so is hereby debarred from participating in any other tender inquiry with FCI for a period of 3 years with immediate effect. So termination plus banning. Now, my lord, before taking your lordship, my lord, through the contract clauses, please have a look to only one paragraph, which is paragraph 22 of the writ petition. Because the bank had FCI had verified from the bank, which your lordship will not find any reflection either in the show cause notice or, my lord, in the termination order. This, my lord, I have pleaded at paragraph 22. Insofar as the petitioners have been able to ascertain, the respondents read its letter dated 17th November had sought for specific clarification from the petitioner's banker with regard to the date on which the check was deposited, when the check was processed, and when the matter was intimated to the petitioner. The petitioner has come to learn that its banker had replied to the letter issued by the respondents indicating that the check was deposited on 30th of September, the check was processed on 7th of October, and the petitioner was informed of the fact only on 11th of October. The respondents are called upon to produce the aforesaid letters dated 17th November 2022 and its reply thereto by its banker. It is also evident that in terms of the requirement of the notice inviting tender, the petitioner had submitted all requisite documents and checked for transfer through an electronic mode in favor of the respondents by its banker within 15 days from the receipt of its acceptance. This was the requirement of the condition of notice inviting tender, and the same has been discharged. Now kindly have a look to mirror the two of the clauses. The first one your lordship finds at page 32. I.
Yes.
The successful tenderer shall furnish within 15 working days of acceptance of his tender a security deposit for the due performance of its obligation under the contract. The security deposit shall consist of a sum equivalent to 5% of the contract value of the contract submitted electronically through NEFT, RTGS, other electronic means in favor of the General Manager, Food Corporation of India. The contractor at his option may deposit 50% of this amount within 15 days of the acceptance of his tender, while the balance 50% may be paid by the contractor by deductions at the rate of 10% from the admitted bills. But the second part will arise only after I start work. The first part is my obligation at his option may deposit 50%.
Right.
The security deposit shall not earn any interest. Then B, another sum equivalent to 10% of the value of the contract in the form of an irrevocable and unconditional bank guarantee issued to the scheduled commercial bank notified by RBI, excluding urban area, etc., in the format prescribed in Appendix 4, shall be enforceable within 6 months after the expiry of the contract, period. Then can you skip over C? Please take II. In case of failure of the tenderer to deposit bank guarantee as stipulated in 7(1) B and C within 15 working days of acceptance of his tender, further extension of 15 working days may be given subject to levy of penalty at the rate of 1% for the whole amount of the security deposit and another 15 working days with levy of penalty at the rate of 2% on the whole amount of the security deposit. Or in other words, for bank guarantee, there can be extension of time subject to penalty, but so far as the first part is concerned, there is no extension of time. Now please take clause number III. Clause number 4. In the event of the tenderer's failure after communication of acceptance of the tender by the corporation to furnish the requisite security.
Sorry, this is which one?
Clause 7(4) at the bottom of page 32. Actually, third line from 3 because Roman 4.
Right.
The security deposit furnished by the tenderer will be, I'm so sorry, in the event of the tenderer's failure after communication of acceptance of the tender by the corporation to furnish the requisite security deposit under clause 7(1)(a) by the due date or requisite security deposit in the form of bank guarantee under 7(IB) and 7(IC), including extension period applicable to submission of bank guarantee only, his contract shall be summarily terminated. Besides, forfeiture of the earnest money and the corporation shall proceed for appointment of another contractor. Any losses or damages arising out of and incurred by the corporation by such conduct of the contractor will be recovered from the contractor without prejudice to any other rights and remedies of the corporation under the contract and law. The contractor will be debarred from participating in any future tenders of the corporation for a period of 3 years. After completion of the prescribed period of 3 years, the party may be allowed to participate in future tenders, etc. Now, yes. Now, there is a force majeure clause, which my lord will find at page 45, Roman 17.
Yes.
The contractor will not be responsible for delays which may arise on account of reasons beyond his control, of which the general manager shall be the final judge. strikes by contractor workers, well, that is, those are not relevant for me. Therefore, my lord, in the background of, my lord, these facts, my lord, my first submission would be, my lord, that so far as I am concerned, my lord, I have done my whatever was to be done on my part, my lord, by 30th of September 2022. Number one. Number two is, my lord, my delayed performance, assumed delayed performance, has been accepted by them without any demur. That is on 12th of October 2022. Number three, my lord, by conduct, I would respectfully submit, my lord, the respondent had accepted this delayed performance because your lordship has found that, my lord, for about 5 months or more than 5 months, my lord, there were no action on their part. It is only when I seek my appointment letter, my lord, the bank starts acting. Therefore, my lord, I would be respectfully submitting that, my lord, by conduct, they had accepted. My lord, I have been visited with termination plus blacklisting or debarment. My lord, your lordships have held, my lord, in a case of blacklisting or debarment, there has to be a clear intention in the notice to debar or blacklist. Here, my lord, it is said that why necessary action will not be taken against you.
What was the page number again?
My lord, the page of
Show cause notice. Yes.
Let's say 119.
Thank you.
Where these, my lord, I'll supplement the last point. Kindly note, my lord, so that your lordship may consider it on the
Yes,
next
yes.
day. The last one is, my lord, if the authorities, my lord, have a document in their possession, they are bound to disclose it to me. They can't say that I have not relied on it, therefore I will not disclose it to you. Where there is a judgment of our High Court.
Have they relied on any document in the blacklisting order? No.
No. The
Now they cannot.
clarification from the bank is nowhere disclosed. Para 22, my lord, that disclosure we have made.
We'll continue on Monday.
I'm grateful.
Heard in part for further hearing on Monday, June 26. হ্যাঁ আপনারটা কনফার্ম করুন এন্ডোর্সমেন্ট দিয়ে লিস্টে কন্টিনিউ করুন
We have filed our affidavit of service.
এটা তাহলে হ্যাঁ
I will